Good morning, everyone. Today is Thursday, August 20th, 2026. This is an agenda meeting of the Minnesota Public Utilities Commission. My name is Katie Sieben. I chair the commission, and I'll take the role of the other commissioners who are present. Commissioner Partridge.
Here.
Commissioner Hom.
Here.
Commissioner Sullivan.
Present.
Commissioner Tuma.
I'm here.
A quorum is present. Before we begin with our full agenda today, I'd just like to take a moment to recognize Mark Fournier, who's at the back of the room and has a docket up later this afternoon. Thanks for standing, Mark. It's his last day with the Public Utilities Commission. Mark has served us with distinction since 1989, and for many of those years, he was an analyst in the telecom unit, helping guide the commission through the implementation of the federal 1996 Telecom Act, which required state commissions to introduce competition and emerging technologies in the telecom space. From 2013 to 2016, as energy work was increasing, Mark worked exclusively on energy dockets, including gas and electric service quality, SIP riders, and cooperative resource plans. He then began easing back into telecom, and his expertise has helped us shape our evolving work. So thank you for your work on more than 1,300 dockets during your time at the commission. Thank you, Mark, and I'll turn it over to Commissioner Tuma, who also wanted to thank you for your service.
Mark, I really appreciate working with you. You're just a steady keel. That's what I always think. You're very steady, always have good advice. I took over the telecom stuff from Lip Schultz. I was clueless, and you have been just a rock to work with. I can't tell you how much I've appreciated the time I've had with you and understanding how the process works. And thank you for your service. It's been wonderful. I hope you have a good time, catch a lot of fish, and do a lot of good things. So, thank you so much.
Okay, our first docket today will be introduced by Jacques Harveau. Please introduce docket number 1.
Good morning, Chair Sieben and Commissioners. Item number 1 is docket number ESS 26184 involving LSP CG Storage LLC in the matter of their application for a site permit for the up to 80 megawatt Cottage Grove BESS project in Cottage Grove, Washington County, Minnesota. The questions before the Commission are, should the Commission require an addendum to the environmental assessment for the project? If an addendum is required, should the Commission authorize the Executive Secretary to approve the scope of an EA addendum? If an addendum is required, should the Commission extend the 6-month statutory deadline for the Commission to make a decision, not to exceed 9 months? Should the Commission issue the draft site permit prepared by Energy Infrastructure Permitting staff, including the proposed special permit conditions? And should the Commission request that an administrative law judge from the Court of Administrative Hearings conduct public hearings for the project and prepare a summary of public testimony as expeditiously as possible? Staff has the following opening remarks. The briefing paper on page 9 mentions updates to sections 1, 2, 2.1, 2.2, 2.3, 3, and 4 of the draft site permit. Staff notes there is no section 2.2 or 2.3 in the draft permit. Staff has no further remarks and is available for questions. Thank you.
Thank you. If the parties could come forward, please. We'll begin with questions from commissioners. Or the applicants online, I guess. So, Commissioner Sullivan.
Chair Sieben, I don't have any questions at this point in time. I'm ready to make a motion whenever you're ready. I know that I guess the only thing I would ask is if the city has any concerns. I think the city is squared away, but if I think Ms. Sabatka is there from the city, or
Who's online from the city of Cottage Grove? If you could please turn your camera on, if you are, or speak up.
Yeah, so that's me. So Ms. Sabatka from City of Cottage Grove. I'm Elena Sabatka, the Assistant City Engineer. As a whole, the city appreciates the commission for including the comments that we had shared, acknowledging the requirements with the city. We appreciate the collaboration and the coordination and look forward to having this project progress with you guys.
Great. And you don't have any problem with the way that the briefing papers lay out where we are and where we're headed? That's clear?
That is very clear. We do not. We appreciate the inclusion of the specific stipulations for our requirements and calling out our specific ordinances. So as a whole, the city is appreciative and supportive of how it's progressing.
And also, thank you very much, and we appreciate the city's involvement in our docket. I know that perhaps Leonard Wabasha from Shakopee, Mdewakanton, Sioux was going to join. Are there any tribal representatives online that wanted to identify themselves or speak to the docket? Okay, I don't see anyone. So, Commissioner Sullivan,
Real quick.
before you make a motion, Commissioner Tuma has a question.
Yeah, Mr. Mueller, thanks for being on. I was noting that there's some discussion about insurance and the BESS project we just had down in southern Minnesota, the Midwater BESS. We had some insurance language very specific to that permit, and our staff did not include any language here in the draft, but I think it's important that we do have insurance language in there. So I was just going to poke at you and say I think that should be part of the discussion going forward to make sure that you put together some language that you're comfortable with in the permit. I think we're still trying to level set how best language and insurance language should be here at the commission. So you're the second test case is trying to figure out what that looks like is what I would say to you. So I'm looking at insurance, and I'm sure we will have that as part of the discussion and probably a permit condition. I just wanted to make sure you're comfortable with working on some language as we go forward around insurance requirements in the permit.
And Mr. Mueller, please identify yourself for the record.
Yeah. Thank you, Chair Stephen, and good morning, Commissioners. David Mueller from Frederickson Environment on behalf of the applicant, LSP CG Storage. We also have a project representative with us from Panama Capital. Connor Klingsig is also online. But appreciate the staff briefing papers and appreciate, we had done a response. We will, of course, obviously have insurance for the project and will, but we'd be willing to work and add additional language, through the process and a special condition or whatever is necessary. Our response at the time, we haven't seen the Midwater written order yet, and so that's why we did the way we responded in our supplemental comments. But we do support the staff recommendations on 3, 5, and 8, including all the special permit conditions for the city of Cottage Grove.
Sounds good. Looking forward to it. Thank you.
Anything else, commissioners? And Commissioner Sullivan, could you make a motion, please?
I'm happy to make a motion. Thank you. First of all, I did want to just note that I appreciated the work that the developer has already done, reaching out to the tribal communities and the work that they've done with the city. And I think that they've shown they put the work in on at least up to this point, and I appreciate that. And Mr. Mueller, I appreciate your willingness to continue working on those issues with insurance. I didn't think at this point it was necessary to include some of the stuff, Commissioner Tuma, so that's why I'm comfortable with moving decision options 3, 5, and 8. And I'm happy to answer any questions.
Is there any discussion of Commissioner Sullivan's motion? All those in favor, please say aye. Aye. Opposed, the motion prevails 5-0. Thank you. Thank you, city folks, too, and our staff. And we'll take up item 2 when folks get ready next. Ms. Maxon and Ms. Johnson, thank you for your work on this. Please introduce the item.
Good morning, Chair Sieben and Commissioners. Item number 2 is for docket number E015/CN-25-111 in the matter of the application of Minnesota Power and American Transmission Company for a certificate of need and route permit for the Iron Range, St. Louis County, Arrowhead 345 kilovolt transmission project. The questions before the Commission are there any contested issues of fact with respect to the representations made in the certificate of need application? And are there any other issues or concerns related to this matter? I have no further remarks, but I am available for questions. Thank you.
Thank you very much. I think this is pretty clear, a procedural decision for the commission to make at this point. I do have a question for the department, if you're available. Good morning. Could you please state your name for the record and the organization you're representing?
Yes, my name is Forrest Idebo, and I'm with the Minnesota Department of Commerce.
Thank you very much for being here. Are you comfortable with I just wanted to confirm that you are comfortable with the staff recommendation that we could handle this certificate of need application through contested case proceedings?
With decision option number 2? Yes, so we absolutely are, yep.
Okay, great. Are there other questions from commissioners? Then I would move decision option 2 to decline to refer the certificate of need application to the Court of Administrative Hearings for contested case proceedings under Minnesota Statute 1457. Is there any discussion? Hearing none, all those in favor of my motion, please say aye.
Aye.
Opposed? The motion prevails. Thank you very much. Thank you to our staff. And next we'll move on to item 3 when folks get ready. Good morning, Mr. Manning. Please introduce item number 3 for us.
Good morning, Chair Sieben and Commissioners. Agenda item number 3 is docket number E999/CI-19704 in the matter of an investigation into self-commitment and self-scheduling of large baseload generation facilities. This docket was last before the Commission on October 23rd, 2025. The questions for the Commission today are, have the utilities provided adequate information in the 2025 compliance filings on self-commitment? Should the utilities be required to provide additional information or take additional steps regarding self-commitment at this time? Should the filing of this report be combined with the annual fuel true-up reporting as recommended by joint parties in the December 29, 2025 letter? And should the filing requirements for future years be modified? Parties and staff are available for questions. Thank you.
Thank you. Should we have the parties come forward first and state appearances? The utilities that are representing, or the people that are representing the utilities and the department, if they could come forward. And why don't we start with Otter Tail, since it looks like Otter Tail's online. So whoever's answering questions for Otter Tail, please identify yourself and the organization you're representing. Or we can't hear you, Ms. Donofrio. I'm not sure why.
About now.
Yes, now we can.
Wonderful. I apologize. We did a sound check, but then I got kicked out and came back in, and everything was different apparently. My name is Lauren Donofrio, and I am the Senior Associate General Counsel for Otter Tail Power Company. And with me to answer questions, I have Ryan Retzloff, who is our Manager of Power Marketing and Generation Operations, and Paula Foster, who is our Regulatory Analyst on this matter.
Okay, thank you. And starting on my right for Minnesota Power.
Good morning, Chair Sieben, Commissioners, Matt Brodian on behalf of Minnesota Power.
Good morning, Lauren Steinhauser on behalf of Xcel Energy.
Good morning, Sydney Lieb with the Minnesota Department of Commerce.
Okay, thank you. And we'll start with Commissioner questions. Commissioner Hom.
Thank you. Thank you, Chair Sieben. I do not have a question, but I think staff raised this question, and then I think I agree with it. The main reason we are discussing this today is because we are trying to change the venue of discussing this issue from this CI docket to the AAA dockets. I agree with it because this docket is mature. I think it has a significant impact to the optimal dispatch of our coal plants. I think that saves a lot of money for our ratepayers. Now I think given this maturity and department's agreement, we can move this to the AAA dockets. When there is an annual true-up, we can discuss this issue as a part of those overall discussion.
Great. Are there other questions for the utilities? Ms. Donofrio, as I know that for Otter Tail, AME is taking effect or has now taken effect, and this docket doesn't cover AME as an operational economic output for your coal facilities. But in anticipation of AME, I don't know how else to say it, like happening now in 2026, what do you think? Or is it too hard to speculate? Is there anything that you're seeing that you want the commission to be aware of as it relates to AME that you see coming?
Certainly, and I will punt that question to Ryan Retzloff, Chair Stevens, as I think he has a better grasp on the day-to-day of how that's working.
Mr. Retzloff, just state your name quickly, please. Thank you.
Thank you, Chair Sieben. Ryan Retzloff with Otter Tail Power. I am the Manager of Wholesale Marketing here. In regards to AME, thank you for the question. The thing that I would note for us, especially with regard to the self-commit filing, is we'll have to figure out how we're going to report that next year. Partial year will have AME in it, and partial of the year will not have AME in it. And what will we want to look at when that split happens? And it'll change the reporting a little bit, and we'll have to maybe have some discussions around that. So far, since June 1st, Coyote AME has run very little. I think through July it was maybe like 7 hours. I think it's something like that. I'm not sure what the precise number is, but it has not been much. And the other thing I would just notice is mention is, there are times when we will see some megawatt hours fall into Coyote AME when we do some necessary testing. I'm not sure if that's been discussed in too much detail, but we will see some generation megawatts allocated there, but they should be very limited as well. So,
and do you think
I'd be happy to answer any other questions.
No, I appreciate that, and I did as you were answering it, made me your point about how it could affect the reporting because of the changes that are occurring. Is there anything that you think we should ask you to do in addition for reporting into the fuel clause docket now that might just be helpful, or that I assume you file information if we asked for it anyway, whether we ordered it or not. But anything because of that change that you think is helpful to include in the reports?
You know, Commissioner or Chair Sieben, thank you. I maybe not be the very best person to answer that question, but I will say that we have set up a new asset owner within MISO to capture most of those dollars as they flow through for Coyote AME. So I'm expecting that all of our dollars and costs will get, and credits will get allocated correctly. So I can't think of anything at this time. I was more kind of concerned about, once we go from reporting Coyote as one entity, and then we get to June 1st of 2026, and we're now splitting it between Coyote AME and the Dakota share of Coyote. How will we want that reported for the self-commitment process?
I'm not the person to ask. Dr. Lieb, do you have any thoughts on this, or further? I assume you can ask questions as this continues to unfold if you need more information.
Chair Sieben, I don't know that we've thought this through completely at this point. I think we would bring it up as the filings are coming forward, but I'll ask Dr. Rackow if he has anything else to add there.
No. He's shaking his head no.
He says no.
Okay.
Surprise.
Well, we can always add, if there's not sufficient information, we can always continue to handle that in the docket. And
Chair Sieben, we would be more than happy to visit with how that reporting format should be changed, since there'll be two different units as we get closer to that time period.
And you're willing to work, of course, with our staff and the department as they want on that
absolutely,
reporting?
yes.
Yeah, great. Okay. Any other questions from commissioners? And Commissioner Hom, do you want to make a motion?
Thank you, Chair Sieben. I can make a motion to move decision option 1 through 5, all of them.
Is there any discussion of Commissioner Hom's motion? All in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you very much, everyone.
Thank you.
The fun begins.
Christian Noyce is our analyst for agenda item 4. Please introduce the item.
Yes. Good morning, Chair Sieben and Commissioners. Item number 4 is docket number E002, PT 7157 / SA-25-129. Involving Xcel Energy and the City of Slayton in the matter of the petition of the City of Slayton for determination of compensation for city acquisition of Xcel Energy electric service territory. The question before the Commission is, should the Commission accept, reject, or modify the findings of fact, conclusions of law, and recommendations provided by the Court of Administrative Hearings? We had a late filed letter of decision options by the City of Slayton, which staff compiled with the original decision options. We also have new decision options submitted by Commissioner Partridge. Both sets of decision options are available in the back corner and are set at the Commissioner stations. We have representatives from Xcel Energy, the City of Slayton, and the Department of Commerce available for Commissioner questions. I have no further remarks, but am also available for questions. Thank you.
If the parties could please come forward, we'll begin with opening statements from the parties. for 3 parties, we have a lot of people who want to sit and not enough chairs. So if you are not speaking right at the beginning, you're welcome to still sit at that second row of chairs and then we can call you up if you want to address the commission or the commission asks you a question. But so because we had some late filed comments and decision options, I thought it would be a good idea to just have parties begin with outlining to us where your final positions are and what decision options or action you'd like the commission to take. And we'll begin this morning, how about with the Department of Commerce, who's on my far left. If you could please introduce yourself and state anything you'd like, I'd appreciate it.
Good morning, Commissioners. Amrit Hundle, Assistant Attorney General. It's not on.
The camera went to you, so I think
we're good. Okay.
Yeah.
Amrit Hundle, Assistant Attorney General, representing the Minnesota Department of Commerce today. The department continues to support its contributions to the record in this matter, and the department supports decision option 1, accepting the ALJ report in its entirety. While all of the final costs have not been finalized yet, based on the information currently in the record, estimated compensation per accepting the ALJ report consists of a lump sum payment of approximately $4.51 million and a mill rate payment of 116.79 mills per kilowatt hour over a period of 10 years for lost revenue. Additionally, based on August 2026 status of DER interconnection queue at the Slayton West substation, there aren't active studies at this time. Therefore, Partridge New 10A decision option may be unnecessary. Thank you.
Thank you. Next, we'll hear from the City of Slayton. And please state your name for the record and then provide comments.
Good morning, Chair Sieben, Commissioners. My name is Josh Weir with Canadian Grant on behalf of the City of Slayton.
Mr. Weir, I'm sorry, but I should have told you, there's a button at the bottom that.
Oh, thank you. Okay.
There we go. So the folks online can hear. Can you just repeat that?
Certainly. Good morning, Chair Sieben, Commissioners. My name is Josh Weir on behalf of the City of Slayton. And the City of Slayton respectfully asks the Commission to adopt the City's decision options Alt 4, New 6, and New 8. The central issue in this case is loss of revenue. The City and Xcel take very different positions on this. The City's expert, David Berg, evaluated Xcel's actual unrecoverable losses during a reasonable adjustment period needed to bring any losses down to zero. His approach is grounded in principles of cost avoidance and mitigation and consistent with Commission precedent. Applying these principles, the City established a full record of evidence showing that Slayton represents less than 1/10 of 1% of Xcel's Minnesota load, and that Xcel can and most certainly will redeploy resources from Slayton to serve other customers. The 4 megawatts of capacity now serving Slayton will not sit idle. They're capacity that Xcel can use elsewhere, delaying new construction and avoiding costs that would otherwise put upward pressure on rates. Xcel's model takes the opposite approach. It relies on overly optimistic statewide projections and assumptions and would let Xcel continue collecting 70% of Slayton revenues while providing no service, while it uses those resources to serve other customers in its growing load base. The ALJ's recommendations did not address the City's evidence on these key points. For example, City witness Mark Fritsch offered unrebutted testimony of his firsthand knowledge and experience as an employee of Xcel in its ability to adjust and reallocate resources after a loss in load within a 5-year period and potentially within even the first year. The recommendation also found only $254 a year in avoidable distribution costs, an amount insufficient to cover depreciation on even a handful of transformers, let alone the $3 million distribution system the City would be purchasing. And most concerning, the recommendation did not even discuss Mr. Fritsch's testimony, the distribution cost avoidance issues that the city pointed out, or the cost savings from redeploying resources instead of building new ones. Touching briefly on the Slayton West substation, the record shows that Slayton's historical load on it uses only 28.6% of the substation's overall capacity, and that the substation remains important for Xcel's interconnection needs. Mr. Berg's treatment of the substation as part of the loss of revenue consideration fairly compensates Xcel for this issue. Lastly, on integration costs, the Commission should award proven costs, not possibilities. Speculative engineering studies, hypothetical DER impacts, and undefined future expenses should not be awarded. Xcel has not shown what these costs are or that they are reasonable and prudent. At bottom, this case asks whether compensation will reflect actual unrecoverable losses or hypothetical future revenues. The record supports only one answer, and the Commission should adopt the city's approach. With that, I would ask permission, Mr. Malchow, the city administrator, also had some brief remarks prepared if the Commission would like to hear them now, or we could wait until you get into the Commissioner's questions. Thank you.
Why don't we hold off and then we'll hear them when we get into questions. So next, Xcel, please.
Thank you, Chair. My name is Ryan Barlow from the law firm of Cozen O'Connor, appearing on behalf of Xcel Energy. Also with me today is Ian Dobson from Xcel, and we have some other folks available if there are technical questions that you need answers to. I want to first clarify what the company's role is in this case. If Slayton leaves our system, the company will lose around $3 million of revenue each year. Unless that can be offset with avoided costs or with just compensation from Slayton, that will lead to a rate increase for our other customers. And our primary goal in this case is to protect our other customers from that rate increase, which would be caused by Slayton's choice to leave. To that end, we have committed that any just compensation we receive from Slayton will be refunded to our other customers to protect them from that rate impact. We generally agree with the conclusions and recommendations in the ALJ report. We disagree on a few technical areas, including the time period and growth rates, but there are two other things I want to call attention to in particular. The first is related to engineering studies. We are supportive of the direction of new decision option 10A filed by Commissioner Partridge. We're happy to provide a compliance filing after any studies are complete. We would propose a change to the scope. While there are some solar interconnection issues, our concern about engineering studies is broader, and I'm happy to discuss this in more detail, but I know you only want 2 minutes here. So we would propose to expand that so that it covers any engineering studies that we are required to do because of the exit of Slayton from our system, and I have some language that I can provide at the right time. Second, we're aligned with the ALJ's overall recommendation on the treatment of the Slayton West substation. But the ALJ also recommended that we be required to provide some additional information after this hearing. We think that we've already provided all of that information. I'm not going to walk through it here, but we listed it on page 13 of our exceptions. So our request is just that we not be required to make that extra filing. And I have language for that to share at the right time. If the Commission does want us to provide more information about that substation, we would ask for some guidance on what you're looking for. From our perspective, we think we've put everything into the record to do that calculation already, and we're not sure what else there would be that's needed. Finally, staff reached out to ask that we have cost calculations available. I've got that if you need it. I confirm that our current recommendation is what we put in our exceptions. It's a lump sum payment of approximately $35 million. I know that the ALJ recommended splitting that into mill rates, and we can provide that calculation. We also have the calculations for the different time periods that are in the briefing papers and decision options.
Thank you. Okay, we'll begin with Commissioner questions. Who would like to begin? Commissioner Sullivan?
If Commissioner Partridge wants to go first, I can, but I just have a couple kind of high-level questions, and in general, I mean, I reviewed the record and I found that ALJ's recommendation kind of revolving around where I was at. You know, I think that the blending of generation planning and distribution planning in 10 years. I mean, I was kind of more like in a 15-year frame, but 10 years I'm okay with. But so I'm kind of in that spot, and I've been looking forward to the conversation here to really kind of titrate in where exactly I'm at. But there was a couple things that I was wondering about from the city of Slayton's perspective, and I appreciate that this all started because of poor service, that though at least some incidents of poor service. I think objectively the numbers are kind of, some years you're up a little bit worse, some years you're a little bit better, and you kind of, but there are some really bad examples out there, like in particular, when the fire department had to come out for 4 hours and water the ground, and I mean that, I think that's unacceptable, and I completely appreciate, your exasperation with that situation. And service in the South has been an issue in southern Minnesota has been an issue that this commission has been focused on. So that's not great to hear that. But there are a couple things that I am worried about, and they're higher level. One of them is, I'm interested in what the community is thinking long term, but would you be in creating Slayton Municipal Utilities? Would that be a forever entity, or would you be coming back to the commission at some point in the future and looking to do basically a service territory swap, where you're going to just hand it all over to Nobles County Electric?
Chair Sieben, Commissioner Sullivan, appreciate the question.
Sir, you just need to state your name for the record, too.
Josh Malchow, City Administrator for the City of Slayton, Minnesota. Appreciate being here today. Appreciate the question. 100%, this is a forever thing for us. We are not looking at doing what I would phrase as a bait and switch to the community, where we sold it to them on a bond issue referendum and a statutory referendum question, and then all of a sudden turn around and do that again to try to make a quick buck. You're 100% correct. We got into this not because we're looking for a cash cow revenue stream. We got into it because we think that we can do it better and more responsive to the community.
Mm-hmm. I mean, under state law, that is the right of the community to do, so I appreciate that. Another question that I had is, how long would Nobles County Electric be? You'll have a contract with them for services. Can you say how long that contract would be? Or, I mean, if you're like, no, I don't know, that's fine too.
Nothing signed yet. I think as part of the record, actually, in terms of Excel's testimony, they did a data request and got some emails, which is completely fine. The draft, not approved by either their board or our board, is 10 years at this current time.
Okay.
And that would just be for O&M. Power purchase, we don't have anything. We can do whatever we want there, of course. That would just be for operations and maintenance and billing.
Okay. And then, okay, I got it. And then another question I had is in regards to community solar gardens. And, I recognize that there are costs that the company has incurred because of the CSG program. And I think that those are costs that, they should be rightly compensated for. But I'm wondering if the community has, when reading the record, I was struck that, was it 1/6 of the residents of Slayton are on a CSG? Is that right? That was the number that's in the record that I saw.
That is in the record. I don't have the information in front of me.
As an aside, I think it'd be kind of interesting to see what percentage of them voted to get rid of the company. But I do think it has I don't know, this commission I don't think is going to have a lot of jurisdiction, but I hope that the city is thinking through, like, how are those people are going to have a fundamentally different arrangement with Slayton and Nobles than they will with Excel. And I would think that, I don't know what you're thinking about regarding a very significant portion of the population that's on CSG programs, that value of solar rate. I don't know exactly what it pens out to right now, but it's probably somewhere in the neighborhood of, $120 a megawatt hour, or,
Less than Nobles.
yeah, it's a lot less than Nobles, that Nobles and the city are going to have to fulfill if those people are going to be kind of made whole. So I'm just kind of curious what you're thinking about with that, or if you're like, well, that's a tomorrow problem. So
It's a little bit of both. It's a little bit of both a tomorrow problem, and also we do recognize that we want to offer the same type of programming that people are able to do now. An issue that we see is, number one, we stand by our testimony that we don't believe just a open checkbook, so to speak, for these ongoing costs to the company is appropriate, but to the ratepayers themselves, that's a different story, and I'll speak to that. There's many different solar developers that have signed up for people in our community for community solar, whether it's 10 years, 15 years, or 20 years. And so when you asked how many people are in it and then generally how much they're getting per credit, that's really difficult to answer because it's so many different developers that have signed people up kind of by way of the community.
Well, CSG would all be value solar, I think. So like that would all be.
But we have in town is people that are flashing the Excel card, so to speak, and they're a third party, and those third parties, fundamentally, they have to all satisfy state statute as community solar gardens are currently set up. But how that third party takes it is anybody's guess. So there isn't a set of contractual terms for every single customer, I guess, is what I'm saying.
Well, I appreciate you, answering these questions. These are just things that are knocking around in the back of this dude's head right now. And I mean, they're not, they're just things that are lurking. I am, concerned about, and I appreciate you mentioning, I was kind of concerned about the bait and switch. Not that we have a lot of authority, we have to, as the entity that protects utility service territories, I think we just have to be on alert for that. We also protect municipal service territories. So it's just something I was concerned about, and also just wanted to hear more from your perspective about, how you're thinking about some of these other practical, what I think of problems. So that's all I had.
Commissioner Tuma?
I can defer again to Commissioner Partridge. I wanted to dive into what Excel thinks about your 15, but I didn't want to steal any of your thunder. I've done some reading on it from the legal standpoint, but I'm comfortable with holding off too. So,
would it be okay if I just provided an overview of kind of what I put together? Okay. So first of all, to the city of Slayton, echoing what Commissioner Sullivan said to you, I am very empathetic to the service quality issues that you had. And I personally would have liked to have an opportunity, through a complaint process to help improve those. So anyway, I just want to say, I think that the service quality issues that you faced were unacceptable to me, and I think to this whole commission. So I want to start with that. However, it's really important for us to make sure that we are protecting existing ratepayers from any kind of cost shift. And as we know, distribution system and the electric system overall is extremely expensive, and that is why we have to socialize it over large groups of people and customers. And so when we take a small piece off of it, it is very expensive. Even the small piece can become very expensive. So in reading the ALJ's report, I think it was clear that what she was trying to do is to balance these long-term assets and long-term planning with the realization that the company can shift and has some flexibility in the midterm to make changes for how they allocate those resources, while also ensuring that they're recovering lost revenues in order to keep existing ratepayers whole. And so I want to start with that I would like to be able to say to the city of Slayton, here's a good deal for you. But in doing that, we would be potentially shifting costs onto existing ratepayers. And so it's just a very challenging, as you know, position for the commission to be in. We are sympathetic to your concerns and your experience, and also really want to be protective of existing ratepayers. I think the decision option 10A that I put in was an opportunity to both recognize that there isn't good data within the record to say whether there will be engineering studies, whether there will be additional costs and what those would be. And so my goal here was to say we aren't saying that those would automatically be considered just compensation and be rolled into that amount, but to say that we would want to see what those costs are and that the company would have to prove that those were unavoidable, that they were caused by the transfer to the city of Slayton, and that they were prudently incurred. And then if we saw those, we would have the Department of Commerce, I'm sure, would review those very closely. We and our staff would review those closely, and you would have an opportunity to review those and respond to them. So it was to recognize that there may be costs. They were not quantified in the record, and we would do our due diligence to make sure that those were unavoidable, associated with the transfer, and prudent. So that's kind of where that came from. I am interested in hearing from the company what additional costs. I want to note that there was conversation in the record around disputes, and I think Commissioner Sullivan brought this up. You have a significant number of residents who are subscribers to community solar gardens. They will, as I understand it, lose those subscriptions. As you mentioned, those contracts between the resident and the community solar garden owner are different. The terms, what expenses those residents may incur when they have to exit those contracts, that's not something that we oversee. It's not something that you oversee. It is very likely to be phone calls that the company receives. There may be legal action between residents and the community solar garden owners. Hopefully that won't implicate the company, but I would be surprised if it did not. And so I did see that you had also mentioned those types of costs of dealing with those complaints and resolutions to those. Can you expand upon what you were thinking in terms of additional engineering studies?
Thank you, Chair. Commissioner Partridge. First, yes, we have raised the possibility for costs like that to help customers who are becoming not our customers. We would like those included if they arise, particularly if there are legal issues that we get entangled in. That will cause costs for our customers. That's not the focus of what I mentioned earlier. While we have mentioned the possibility for engineering studies relating to solar gardens that are in the queue, our actual greatest concern about engineering studies is just related to the loss of Slayton load from our system. The substation near Slayton, called Slayton West, serves almost entirely and only the city of Slayton. It right now has very substantial generation from community solar gardens and some other distributed generation. If Slayton exits our system, we will lose almost 99% of customer load from that substation, which creates a situation where you've got substantial generation and almost no load to balance it. It is our obligation to make sure the system is safe and reliable, and we are going to have to do engineering studies to make sure that that substation remains safe and reliable if Slayton exits. We haven't done that work yet because it will be expensive, and we don't want to do it until Slayton has confirmed that they're going to leave. If we do the engineering studies, and there's going to have to be transmission studies as well, it is possible that they will say everything's fine, and then it's just the cost of the studies. It's possible they're going to show you need significant upgrades to the transmission system or the substation, or that you need to curtail those community solar gardens until changes are made. All of those costs, if they happen, would be caused only because of Slayton's decision to leave the system. I understand that we haven't quantified it. We don't know how until the studies are done. But what our primary interest is, our other customers shouldn't have to bear those costs. And so our recommendation would be to modify new decision option 10A by just striking the words secondary solar interconnection studies, so that any engineering studies that we have to do and any upgrades they identify would be within the scope. We're entirely comfortable with the idea that we have to prove that the studies were needed. We have to prove that the upgrades identified were needed and prudent. We don't object to that at all. But that would be our proposal on engineering studies.
You know, Commissioner Partridge, I'm fine with this old small-town attorney kicking in. Why don't you just say what you just said as opposed to any? I would be worried if I were representing Slayton, that is wide open to any study. If it's substation, and we limit it to the substation and transmission connected there too, I think adding words to it as opposed to deleting words would make more sense. Your comment to that, Mr. Barlow.
Commissioner Tuma, I don't have any objections to adding more words. I thought it was just easier to take words out, but if you'd like us to develop that language, we can do it right now, if I have a couple of minutes.
We can do it, well, at some point, but I would feel more comfortable adding what you just said as opposed to leaving it open to studies. Having gone through CSG world, it makes me a little nervous.
Mm-hmm. Yeah.
Just want to ask something really quick, and I know I don't want to, while we're on CSG, I just want to be clear to the company. The company would not, I mean, we would have to pay for engineering studies, you'd have to pay for an analysis of what the impact would be, how the system changes around it. I get all that. But I do want to be clear, the company would no longer be paying the CSG tariff to those developers, which then flows through to ultimately the person who, the member of the CSG or the subscriber to the CSG, right?
Thank you, Chair. Commissioner Sullivan. I think I understand your question, but if I miss it, just please let me know. So we have confirmed that the CSGs themselves are outside of city limits, so they'll continue to be, active community solar gardens. We will continue to have to pay them the value of solar rate for whatever they produce. I don't know what their relationship is with the customers living in Slayton, but yes, the customers in Slayton that are getting bill credits would not get bill credits any longer.
So the developer would get a credit, but the person who is in Slayton, because they're no longer a customer of Xcel Energy, are no longer qualify for the credit, right? The subscriber no longer qualifies for the credit because they're no longer a member of, or they're no longer a customer of Xcel, a ratepayer.
Chair, Commissioner Sullivan, yes, that's right. We're going to continue to have to pay the solar garden developer for all of the generation that they produce, but any customers that currently live in Slayton won't be eligible to be a subscriber to the solar gardens because they won't be Xcel Energy customers any longer. It's a tough situation for those customers. There's not a lot that we can do, but we wanted to make sure, there's the engineering issue with the queue, then there's this issue about existing customers, and there's some of these things. These are new issues that we haven't seen before, but we wanted to make sure that the commission was aware of them.
Thank you.
One more follow-up on that, if I can.
Yeah.
Mr. Barlow, when you said that the company would have to incur legal costs for disputes from subscribers, why would the company have to incur those costs? Because wouldn't it be up to the city of Slayton now if Slayton's saying, people within Slayton who are current community solar garden subscribers are going to have to talk to the city about why they lost their CSG subscription, not Xcel.
Thank you, Chair. Thank you, Chair. There are a few things that we can see as potentials. Our hope and what we believe is most likely is there's no legal disputes. Like, this can just move forward. Slayton can decide what they want to do and it can be executed. But if customers have contracts with developers that are Xcel Energy solar gardens, it may not be clear to customers that we're not responsible for those solar gardens. And we could get embroiled in those disputes. We also think there's a possibility that if Slayton exits the system, we're going to have to curtail some generation from those solar gardens to keep the system stable until we can do engineering studies. We don't know if that's possible, if that's going to happen, but it's possible. This situation is so new. We've never experienced the loss of an entire city from our system before. We think there's some legal risk. Our point of view is that it shouldn't be on our customers to pay for that. But I also want to say the legal risk issue is not, we think that's good to include, but it's not the most critical issue to resolve today.
Commissioner Partridge.
Can you explain, Mr. Barlow, if you curtail the community solar gardens in that area, what happens? Do the developers just lose revenue? Do you have an obligation to pay? Tell me.
Yeah, thank you, Chair, Commissioner Partridge. I don't think it's entirely clear because, again, I don't want to keep restating this, but it's not happened before. If we have to curtail, we don't want to pay for energy that we're not receiving. And so that would be our intention. What rights the developers have in that situation, I don't know.
And is the logical result of this that if the commission moves forward now, that will be a dispute between Xcel and the city of Slayton to further resolve? Or is that something that you anticipate will come back to the commission?
Thank you, Chair. My hope would be that if any of this comes up, we can work cooperatively with the city. I know we're here on a dispute here, but we're happy to work with them to resolve anything. I don't think that sounds like a commission dispute to me. That sounds like a court dispute.
And for the city of Slayton, any response to this exchange specifically about CSGs and because I would assume, like my fellow commissioners have picked up in the record, some of your constituents will be concerned if they lose the subsidy they're getting from their CSG provider. And I sort of heard through your comments earlier that, that's between the subscriber and the developer to work out that subsidy that they're currently getting. And it won't necessarily fall on the city of Slayton. But then when this exchange just happened, it sort of brought up additional complexity. So what's your response to what you just heard, and what guidance can you give the commission that I think one thing too is we have had a history, and since the community solar garden's inception, like a lot of interest from constituents and a lot of questions that come to our consumer affairs office about it. And I anticipate this will continue in this instance, but is the city pretty comfortable taking on that you're going to have to proactively talk to your constituents who are community solar garden subscribers about what this means for the subsidy that they get right now?
Thank you, Chair Sieben. I think there's a couple of issues there in your question, and so just to kind of take them in order, I would agree with you that the city is comfortable working with the citizens in Slayton to deal with the CSG issues, and so I think the city is fully prepared to do the outreach and work with folks to talk about and understand that part. In addition to, I would echo that the department's witness, Mr. Teagland, put in pretty substantial testimony about the kind of the contracting nature of the different providers out there, and how those would be issues between the subscriber and the developer, and to which neither Xcel or the city are parties, right? And so the company is unfortunately asking the city to kind of indemnify it against any possible claims that might come up that could potentially fall back on the company without ever seeing those claims. So our position is just simply that any claims that come up in the future should just stand on their own merit. And if they come up, we can, as Mr. Barlow noted, we can try to work those out, or if we had to litigate those, we could do that. But at this point, we don't even really know what those claims would be, who they would be against, if they would be against the city or Xcel or anybody. And frankly, we think that that's something that should just stand on its own merits and not be predetermined to fall completely on the city of Slayton.
And what about what Mr. Barlow said about possibly having to curtail some of the solar gardens in the area?
So with respect to the engineering studies at the substation, I would defer to Mr. Berg to answer those questions about the engineering nature of how the load flows through the substation.
Yes, thank you. My name is Dave Berg. I'm a consultant for the city of Slayton. One of the interesting things about this is so the company is claiming that at times without the city load on their substation, that let's say those electrons will flow out of the substation. What they're not pointing out is the fact that, and it's already constructed, is that Nobles Co-op has built a new substation, I don't know, a quarter of a mile down the road. That's connected to the same transmission line that Excel substation is connected to. So what will happen is those electrons would, they would flow out of the substation, quarter of a mile down the road and back into the city through the connection to the Noble substation. I've actually done a fair amount of transmission and distribution planning in my career, and this is not an issue. In fact, I can tell you right now that there are many times when the city of Slayton load, let's take a nice spring Sunday when the load is very low, that those community solar gardens already are probably generating more power than what is being consumed within the city of Slayton. And yes, in fact, those electrons are flowing out onto the transmission system. But the way our system is designed and built, it handles that. That is not a problem. And I think from an engineering perspective that this issue is just not an issue. I just think it's one of the many things that they've sort of put on the plate to try to make this as difficult as possible for the city of Slayton. But I simply do not see this as an issue.
Okay, thank you. Commissioner Partridge, sorry, I kind of interjected earlier.
Thank you, Chair Siebert. So it's a follow-up to that question. So CSG units are still under Excel because it's physically under Excel, but losing 221 subscriber means that significant portion of that energy becomes a non-subscriber energy. What will be the rates Excel will pay that the CSG owners? Is it avoided cost or is it similar to current CSG rates?
Thank you, Chair Commissioner Hom. That's a good question. I don't think it has not come up in this case, so I don't know that we've done that analysis. I think that you're right that it might be the non-subscriber rate, but I can't confirm. We can look into that and get back to you if that's something you'd like to know.
Yeah, I don't know exact portion of that 221 subscriber is guaranteeing that units, but if it's significant enough, I had a concern that those CSG unit may not be economically viable. Then what will happen under that case?
Well, Chair Commissioner Hom, that's something we're concerned about. If this happens and those solar gardens essentially go out of business, we don't know what will happen. And part of our interest, again, is making sure that whatever happens there, none of that rolls back on our other customers with increased costs.
So what is Excel's obligation under that case?
Thank you, Chair Commissioner Hom. I think that's a good question, but I just don't know the answer to it.
Okay, thank
you. I want to talk a little bit about your 10. I like Commissioner Partridge, where you're going with 10 and the concept of 10. And to me, what's critical for this commission as we walk out of this hearing, we get to a clear, identified final number that's not disputed, that we're not leaving anything open. And Len, I don't know if you could put up some additions that I thought to this, because I think that's what I'm struggling with, and I think that's where you're trying to get to, because I don't want to come back here and get into more disputes unless we have to. And I like to put a nail in this, and that is to require them to make a compliance filing, pick a date, let them pick it, and then they tell us what these costs are, and then further, we have them complete what they think the final compensation, let's say English words now, what the final compensation is. Excel tells us what that is. It's like, to me, it's a real estate transaction, okay? I don't go into a real estate transaction until I have the seller tell me what price they're putting the property up for, and if I have any escrow afterward, I need to know exactly how that's going to be determined. And then there's objections within 10 days by the department or the city. And so I'm just trying to build off of what I think you're trying to accomplish here, and I certainly would be open to the language that they had talked about adding to it regarding the substation, because I hear a lot of things that everybody's saying are related. I don't think they are, but we'll find out once we do these studies and that we do our order today, whatever that's going to be, and we can get that number in the record so we can set a date and say we're done, because that's our job, is to come up with the number of the sale. So I just throw it out there. You don't have to agree to it now. I just wanted to get it out there since we're talking about new 10. I would like to build on it to create a this is it, we're done, good luck.
Thank you, Chair. Commissioner Tuma. As I said before, we've got no problem showing our homework here. I have two thoughts about this. The first is that this work and the cost to do the work, the studies, are really only needed if Slayton decides to move forward. And so this case is to set up just compensation, but Slayton then has a decision about whether to move forward and when. And so if Slayton decides not to move forward, or if it takes them some time to make that decision, for example, if the transfer's happening a year and a half from now, I'm not an engineer, but having spoken with the engineers, that timing means like how long are the results of an engineering study good? So we will do it, but our intent was to not do the studies until Slayton had told us they're going forward, so that we know that the results are most accurate. I don't think that this timing fits perfectly into there. I'm not sure right now how to solve it. The other is that I would just want to make sure, and it's our intent, that we do the studies and then we talk with Slayton about them. So whatever timing is set, I want to make sure there's time. Like, our preference would not be we do the studies, we file them, the Slayton only has 10 days to object. Our preference would be we do the studies, we meet with Slayton. If they want to have their engineers look at it, they get that chance. We resolve it without having to come back to the commission.
This is my frustration with this whole thing, is if we're going to keep dragging things out forever and ever and ever, our job is to come up with a compensation rate. And I was hoping that we could accomplish that today. I mean, it sounds like the department has given me a number from the ALJ, but you seem to keep wanting to throw things in. And so that's what I'm struggling with here. I want to give a number. That's our obligation and duty to Slayton. They petitioned us and they asked for a number. I want to give them a number, and you're telling me we can't give them a number.
Thank you, Chair. Commissioner Tuma. If the commission tells us to do the studies now, we will do them. But what that means is there's a possibility that when the transfer happens, something about the system has changed. That means it's different results, and then we can't recover that from Slayton, and it's our other customers paying for those costs. Our primary goal is to avoid that. I understand the goal that you're trying to set, and they're in conflict.
So Slayton, help me walk through this. I'm trying to get you a number. I don't know what you're looking for today. My goal was to give you a number. I actually think I would have found in your favor if I was the ALJ. I thought you meant your burden, but that's neither here nor there. We have to have that discussion later. But I'm looking at this now, post whatever we decide, because the five of us have to decide. I'm trying to get to a final, this is done. I also don't want to shift costs onto other ratepayers. So help me out. What would you recommend as far as let's get the final number and this docket is closed?
So thank you, Commissioner Tuma, Chair Sieben. I think the Tuma modified new 10A, I think it achieves what the city has asked for in this, and that it provides for some close scrutiny of whether these costs are necessary and prudent, and for us to actually look at what they are. And so I think from the city's perspective, we would be okay with something similar to the proposed option that's up on the screen here, with the idea that I don't disagree with Mr. Barlow that it would be nice to talk to them about it, but I also think that 10 days to look at a study and say whether or not we have objections to it is more than adequate, right? To just look at it and see if we object. And so I think, that doesn't mean that we can't then talk about it after the fact. And so I think this option as modified sets up a
Would
kind
you
of
be
scheme for
willing
dealing
to,
with these costs.
their concern is, they're going to do a study, and they're going to give it back to you, and it's going to be, an absurd number. Your expert witness is convinced it's not going to be an absurd number. That's where I'm going to guess it's going to be, okay? But, again, let's say it's an absurd number, and you guys all decide, you know what, we're pulling the plug. Nobles, we're not going forward. It's done, okay? At some point, I don't want to pay for that study, okay? Is there a desire or an agreement that you have as far as study payments that you have if you do not go forward?
Good question, Commissioner Tuma, Chair Sieben. That's not something that we've talked about. I would say that, coming up with an estimate of these costs is not the same as doing the full study, right? I think it would be reasonable to require an estimate of the costs. It should be something less than actually having the engineers crunch all the numbers and do the study. Because as I understand it, what Mr. Barlow is talking about is the study itself, plus then all the things that the study then recommends, right? Mm-hmm. And so I think that's a level of detail that's not absolutely necessary for what we're talking about here. And so I think our compromise would be to ask for estimates, at least that we could look at and potentially object to the estimates.
Thank you, Chair Sieben, Commissioner Tuma, and then to the City of Slayton. Appreciate that, but the issue that I'm concerned about is that we do an engineering study, find there are required upgrades, and we've already given you a number and you're on your way. Mr. Barlow, who pays for the upgrades if that happens?
Thank you, Chair. Commissioner Partridge. It would be our other customers. It would be included in rates.
The problem that I see is that we can't legally tell them they cannot recover those costs. We can't tell Excel to eat those costs. That's unconstitutional. So I am very uncomfortable with the idea that we just set a number so that you can make a decision, and then we find out that there are significant upgrades. We find out that CSG owners are suing Xcel Energy because they're being curtailed, or any other number of things that are in this record, and then existing customers are just paying those. You all have left the system. We have no authority to come back and tell you that you need to help pay for those costs. This is a real challenge. I guess I'll ask you, as we've said, we are all really sympathetic to the service issues that you're experiencing. Did you consider just filing a formal complaint with us so that we could initiate an investigation and require upgrades? I know that takes time, but so does a transfer.
Thank you, Commissioner. We're fixating on a couple of things here, and I think we're, in my opinion, maybe missing the forest of the trees here. We initially started talking about this over 4 years ago as a city council and a community because of the service issues, and it blossomed into more than that. It's the fact that end user rates are 19.5 to 21.5 cents per kilowatt hour, and in our feasibility study, we're significantly lower than that. And so it's, in a nutshell, in one sentence, it's we think we can offer better, more responsive service for the same or cheaper rate. And so it is not a wow, you guys kind of flew off the handle here because you have some service issues. It is a list of 4 or 5 things and not just one. The community solar garden thing is so unique because it is a program that's in state statute and is, to my knowledge, somebody correct me if I'm wrong, only with Xcel Energy, yes. Right? And so we, as a community, are not saying tough, everyone. We don't care about your community solar garden subscription, but Nobles nor Slayton Municipal Electric has the opportunity to mirror that program because we don't have the statutory authority to do that. So we are sympathetic to people losing their credit. We have every intention of offering rebate type of programs that Nobles already has. We would mirror their programs, or off peak, on peak. Is it solar? Perhaps not. Is it other energy usage based programs? Absolutely. So, but as the testimony has already showed, and we've kind of said a few times here, I don't know if the community solar garden issue is directly part of this discussion today, because it would be between the subscriber and the, whereas we're just the just compensation part.
Sure. Mr. Malchow, I appreciate that. I think from my perspective, it's not that I feel strongly that those subscribers deserve solar garden subscriptions. That's not what I'm voicing a concern about. I appreciate that you will have other opportunities for them to enroll in perhaps other programs that can provide similar benefits, whether they're solar or not. That's great. The issue I have is all of the complex contractual agreements that both the subscriber has, and how that will be with outside of our jurisdiction, but may implicate the company, may implicate the city. Again, not my problem, but also then the obligation that the company has to those CSG owners, and the costs that could put on other ratepayers. It is a program. They are there. They exist. So we have to think about the costs that they will cause to Excel's system, because we don't want additional costs to be borne by existing ratepayers who are outside the city of Slayton. And this is very challenging because it isn't just a real estate transaction. You're not just buying a house. You're not just buying assets. This is a long-term service as well. And so it is very challenging to say, here is the amount, we're going to include this lien, we're going to put it all together. It's a one-time payment and then we move on, because there are all of these additional pieces that we don't really know what they're going to cost. I'll just leave it at that and turn it over.
That was really helpful, Commissioner Partridge. Thank you. And my question, sorry, did you want to respond to Commissioner Partridge? Please, go ahead.
If I may, Chair Sieben, Commissioner Partridge, I see that there's two issues, right? So one is the potential litigation between subscribers and the developers. And so our position on that is that that's litigation, and to the extent that overflows on either the city or the company, those are 100% issues that can be dealt with in the litigation, right? So if somebody sues and it goes to the company and they disagree with that, they would have the right in that litigation to implead the city and say it's not our fault, it's the city's fault, right? And so we could deal with those issues in those cases.
Let me just stop you there. Who pays for their lawyers?
Again, that's something that we could address in that litigation. There's attorney's fees provisions in some of these things. I don't have those in front of me. I'm not sure how any of that would go. And so we're just asking that the commission not prejudge that and let those claims stand or fall on their own merit, and that we would work those out at the time. So those are the first thing I wanted to respond to. Secondly is just, again, the issue of the engineering studies related to the transfer. And I think our testimony was pretty clear that we generally agreed with Mr. Tegeland on that, and that our two expert witnesses, so Mr. Berg and then Mr. Mitchell, both looked at this and said that there did not appear to be any kind of transition or transmission interconnection study required by MISO, but that recognized that XL may have its own business practices, that it perhaps would want to do one, right? And so to the extent that XL wants to study something, we feel that that's their optional kind of exploratory thing, that if they wish to do that, that's not necessarily caused by the city's leaving the system, right? It's not mandatory by MISO. It's not mandatory by the commission. It's just Xcel is choosing to do this. And so that those costs should not necessarily fall back on the city.
To the city, the voter approved amount, I can say the number, is $7 million. That is the initial payment, is my understanding. And then there's the mill rate that's added on. I mean, that wasn't contemplated in the voter approved referendum, was it? Is there, like, does the mill, my thinking here is that could we adjust the mill rate to account for the unknown CSG costs? So essentially, like, once we know what the result of the CSG leaving the system and what Xcel said about there could be real costs that are borne by Xcel ratepayers, could those costs, so that they're not coming on to Xcel ratepayers, be subsumed into the mill rate in some way so that you would still have an initial payment that is, if we did the ALJ's suggestion, it's still under the cap that your voters approved, but then the mill rate could escalate to account for the true costs for Slayton to take over the service territory. And that could be determined the mill rate could be adjusted through a different process, or I don't know what it is. I'm just trying to think through how we solve this, because to my colleagues' points, we need to know what we're approving so that we're doing our due diligence to come up with fair conclusion for Slayton, but also for the rest of Xcel subscribers who we know that we can't have them bear significant costs, because that would be unjust and unfair. So do you understand my question? Does it make sense?
It does. Hopefully you understand my answer, because that might go on a little bit too. I would, Commissioner Hom asked very specific questions about this. What is the specific financial impact? Who pays subscribers versus the tariffs and all that? Nobody in this room, including myself or Mr. Barlow or anybody, seems to know that answer right now, today. And so I think if you're asking, I'll answer your question in two parts, Madam Chair. I think implementation-wise, yes, that's if the commission orders that as a future adjuster to the mill rate, certainly. Politically, fiscally, does that mean that we would agree with that? I would say no. I mean, that seems like this open checkbook type of idea that we've opposed in our testimony thus far of this ongoing CSG issue that right now nobody can answer if it's going to fall directly on the Xcel ratepayers. I understand completely that it's within the purview of the commission to protect those ratepayers after we exit the system. But I'm not hearing that anybody knows that, whether that damage, so to speak, is going to truly happen or not yet. In relation to Commissioner Tuma's proposed language, Mr. Weir's already answered that generally, but Mr. Barlow is saying, well, we don't want to do anything until we know that Slayton is going to leave. Commissioner Tuma questioned him on that, and I would mirror those questions like, well, we can't say that we're going to leave. If the acquisition cost is $50 million and the mill rate is 116.79, that's
not going to work.
That's not fiscally responsible for the city of Slayton in any way, shape, or form.
Mm-hmm.
So if the acquisition cost is $4 million and the mill rate is 4.5 mils or 20 or whatever, then we can have a discussion. But if the order from the PUC is going to be the 4.5 and then the 116.79, like that's the main issue here. And I understand that CSG is part of that mill rate calculation, but is it the most large part, or are there other things that we need to talk about here to see where that mill rate is at?
And Mr. Barlow, for the company, in your estimation, is the adjustment of the mill rate something that could be a path forward for the utility for Excel to come to agreement with Slayton?
Thank you, Chair. I'll say first that we would prefer that it be included in the mill rate as opposed to excluded. But as I understand what you're suggesting, what that would involve is that we do the studies. That will have some cost. And it may be, as Mr. Berg suggests, and we don't have to do any upgrades, and that's a great outcome. We feel that it's only responsible for us to do the studies. If significant upgrades are required, putting them in the mill rate, what that means is we outlay all the money to make those investments, and we recover it over time.
How long would it take you to do the engineering studies that we're talking about here?
I have that
6 months
question
or a
out.
year or 6 weeks, or give us a sense.
Thank you, Chair. I have that question out to the team, and I don't have an answer yet. I don't think it's a year. I don't think it's 6 weeks. I'd hope it's less than 6 months, but it depends on the complexity once we get into it. And again, I don't want to overcomplicate this, but there's an active interconnection queue in the region. As Ms. Hundle noted, those projects are currently not moving forward. But if projects, like part of the issue is when you're losing load and adding gardens, like there's multiple studies happening at the same time, and our engineers just haven't done that before.
I mean, so it's not a good resolution then to just like table the issue and wait for you to do the engineering studies, because then the city would be waiting, and those, I mean, and I'll turn to the department for what they recommend, but it seems like we don't have a full record to like determine the just compensation for all parties here. And I guess I'm just trying to be like, what's the way out of this? And how long will it take to have a fuller record so then we can decide?
Thank you, Chair. The first thing I want to say is I do think you have the record to move forward. I understand that it wouldn't be Commissioner Tuma's preference, but we think the commission can and should move forward today with the recommendations, recognizing that some of these issues about engineering studies will get resolved over time, and if there are disputes, those
but
limited issues can come back.
Are you just saying, Mr. Barlow, you're fine with Excel ratepayers taking on those costs then? Because like that's a solution for Excel, is then like the commission's left with passing along the costs for significant CSG costs that you've alluded to. And then the commission is left with saying like, you know, Slayton's out of the picture, and Excel will come to us and be like, well, you said we had to do this, so here's the bill, pass it on to ratepayers. Like it's not a great solution
Thank you, Chair.
for us here.
I apologize if I misspoke. That's not at all what I was suggesting. What I was suggesting is the commission should find that those things will be included in just compensation at the time of the transfer. With an order point like that, we're comfortable getting to work.
Because then, sorry, just so I understand, I'm sorry I'm slow. You're saying some of those costs could be incorporated into the mill rate, even though we don't know what that is? And then, or you're saying, sorry, I don't get what.
Yeah, I thank you, Chair.
Engineering studies and this cost attributable to the CSG, like leaving the system or not, how did those costs not get passed back to Excel ratepayers?
Chair, I think the only potential risk, if the commission moves forward as we have recommended, is if we do the engineering studies and then Slayton decides not to leave. Those would be costs I'm assuming Slayton, I mean, we can talk to Slayton if Slayton's willing to cover those, but those costs are meaningful, but we don't anticipate that will be like, the studies themselves won't be many millions of dollars. So we think that's a solvable problem. In the alternative, as we have indicated in our papers, if Slayton is willing to agree that they'll pay for the studies, we'll get going immediately. Like that's something we're prepared to do.
Commissioner Partridge.
Thank you, Chair. I think just to clarify that I think different from Commissioner Tuma's interpretation of what just compensation would be, the ALJ didn't determine a number, but instead the formula. And then my additional decision options build on that formula, which means there wouldn't be a number today. There would be sort of a formula that says the ALJ's recommendation is this. It does include a mill rate, but then it would leave open other categories to be calculated. And I think to the city of Slayton, that's perhaps inadequate for you to feel comfortable making a decision because we don't have a number. I think from my perspective, it's a chicken and egg thing where we don't know the number because, first of all, this is novel. We've not had this happen before. I think the ALJ mentioned we have done territory transfers, but we've never had municipalization happen, at least in recent history where any of us can remember or find it. And so we're walking into this unknown and having a specific number and choosing that and selecting it today, to Chair Stevens' point, leaves us open to potentially additional costs getting borne by existing ratepayers, whereas leaving it open to a formula-based definition of just compensation leaves you all open, the city of Slayton, to potential risk that studies identify upgrades, study costs are higher than expected, and you have to bear that, or litigation from CSG owners, et cetera, et cetera. So I think I feel like we're stuck in between a rock and a hard place where I feel like I don't want to give you a specific number and then find out later that there are additional costs and now you're gone and we have no choice but to pass them to ratepayers.
I think that's where I was trying to get to, Commissioner Partridge, is that at some point we have to come up with a number and we have to just do the studies. I mean, that's why I was trying to build off of your number 10. You're saying, let's go and let's get that stuff done. And I agree with your formula argument. We're not going to get the number today. We're just going to get some path forward. But I would like that path forward to have an end. And so that's what I'm trying to say, let's just do this study, okay? Frankly, the CSG argument about the subscribers, none of our business. I mean, it's going to be a mess. I think we've let them know that's going to be a mess. And I think they know that now, and it's not our problem. Okay, but the problem is that distribution system and transmission system interconnect and how they interrelate to each other needs to be studied, and we need to know if there needs to be any upgrades to the substations. And it sounds like they're not worried about it. Even I've heard indications they're not too worried about it, but we just need to know what the cost of the study is. And if it were me sitting there with my clients, I would say, you know what, client, let's just split the cost, okay? This is our escrow here. Let's just split the cost of these studies. Before we agree to that, though, they have to give them an estimate of what the study's cost is going to be, and they have to be okay with it. I'd probably add that to this decision option. Within 10 days of today, they have to give them an estimate of what those costs are, and then let's let them work out these last details after we know what the cost of this study tells us, and that should give us a number. That's what I'm thinking, but I could be off in la-la land.
We won't comment on that.
I know what the vote would be. 5-0.
I think
4-1.
No, 5-0. I think. You would be with me on that? Thank you, Joe.
Mr. Barlow to respond to that, and then.
Thank you, Chair. I apologize for raising my hand. I don't have a response. We've heard back on the timing. What we're hearing right now is that the distribution study takes 4 to 6 months. The transmission study proceeds on MISO schedule. So we understand that happens quarterly, and if it's unusually complicated, could take a couple of extra months. If upgrades are identified, that extends the MISO timeline, and the MISO timeline is not entirely in our control.
Commissioner Sullivan.
This just gets stinkier and stinkier. I mean, I guess, Commissioner Toomer, one thing the way that I heard Mr. Barlow's response to one of my questions was that the CSG problem would become our problem if XL ratepayers are paying for basically like ghost CSG facilities that there are no subscribers to anymore. Like, and then those facilities would have to be curtailed. I mean, that would be millions of dollars that would be going for effectively nothing.
Why isn't that in the record?
Well, precisely. I 100% agree. Why isn't that in the record? I'm a complete agreement with you on that. But I don't know. Like I do want to say, like, I am super annoyed with Excel. Not you two personally, but I'm annoyed with the company because this is a problem that the company created with the service. And you know, we've been having issues with service in southern Minnesota for a long time, and I think it's been getting better. But I mean, the examples that I read in the Star Tribune and some of this is like just completely unacceptable. And now you got the community that is completely 100% against you. And this is a problem that created, the original sin is the poor service that this company rendered in the city of Slayton. And
Thank you, Chair.
I know, Mr. Barlow, I'll give you a chance to respond, but like, but I really am sitting here today and I'm thinking, and I really appreciate all the work that Commissioner Partridge has done in this conversation, but I'm super uncomfortable. Like, we could set up a formula, the city of Slayton's not going to like that. We could set up a number, and then Minnesota or XL ratepayers are completely at risk. And like, I mean, you know, to the city, like, I totally agree. You're like, well, yeah, I don't know what the number is going to be. Like, that could be a blank check. I mean, the flip of that is what we're facing. And I have no faith that, you know, you guys are going to come back with some of the, you know, the engineering analysis, and I don't think the city is going to be cool with that. I think they're going to be like, oh my God, this is ridiculous. And I mean, I don't know. Maybe this is more of deliberations and not questions, but I'm just like.
Let's let Mr. Barlow respond.
Thank you, Chair.
And then
Commissioner Sullivan. I do have to respond on the service quality issues. Commissioner, I recognize your frustration. There have obviously been incidents in Slayton that are very unfortunate. We're trying to walk away from those. Those things should not have happened. But I think it's also important that the decisions in this case not be made based on specific incidents. As you acknowledged earlier, when you look at the long-term data, Slayton's reliability is relatively similar to the rest of the region, which is not that different from the rest of the state. Some years it's up, some years it's down. I also want to make clear, as we put into the record, when Slayton brought their concerns about reliability to us, we responded. We have replaced thousands of feet of distribution line in the city in the last 4 years. We have replaced hundreds of distribution poles. We have spent tens of millions of dollars to rebuild the transmission system in the Slayton region. That's an example of us being responsive to the needs of our customers. I understand Slayton's frustration and the genesis of it, like, we get that. But we have taken significant actions and made significant investments to make reliability in Slayton better. And I don't want that to go unaddressed here.
And we'll let the city respond and then get to Commissioner Ham's question.
Very quickly, and my council wants to respond to the improvements just so happened to coincide with the filing of the contested case hearing and not really any moment before that, which was about a year and a half or 2 years.
And sir, state your name and you're welcome to respond too.
No, it's a different type of dot.
Hi, my name is Blake Hieronymus. I'm on the Slayton City Council. Thank you all for your time. Mr. Sullivan, I feel the exact feeling that you are. I'm super annoyed here. All along this entire process, these are the kind of things that XL has been bringing up to basically muddy the waters and try and make this not happen. I believe, if they truly thought that these were issues, they would have brought them forth by now. They've had plenty of time to do so. I think they're just bringing them up to further muddy the waters and try and make this not happen. As far as the community solar gardens, now anybody can correct me if I'm wrong here. At one point in time, the community solar gardens needed to be right adjacent to the community they were serving. That's no longer the case, correct? So those community solar gardens that are in Slayton, in a sense, could be resold to or subscribed to a subscriber right here in the Twin Cities. From what I'm personally seeing with the people trying to get subscribers signed up, they're knocking down the doors. I honestly don't think they can build the community solar gardens as fast as they're getting people to subscribe to them. So I personally don't think it would be an issue if the Slayton subscribers left, because there's plenty of opportunity for them to go elsewhere. I think the developers would just resell those subscriptions. I also think they're just using this as another excuse to muddy the waters. That's my opinion, but it makes real good sense to me. Thank you.
Thank you. Commissioner Hom.
Thank you, Chair Stephen. So I'll just turn this discussion a little bit in different direction. I think the city mentioned that not only the service quality, they're concerned with the rates. So I want to give you the facts you need to consider if you are really worried about the rates. Because based on deal, what I see here, you are going to have only flexibility with the generation portion. You are going to take a transmission service from Excel because you are located within the Excel service area. In the wholesale rates, you are neutral. However, in the Excel retail rates, Excel is supposed to credit ratepayers with a certain credit. That's not going to be your credit anymore if you get out. So you have to put that in the condition. And then generation side, these days, there's no such a thing as excess capacity. That means you have to buy brand new capacity, most likely, which will be very, very expensive these days. As of now, Xcel Energy, I know you are not happy with their rates, but at least in the generation portion, they average out all their fleet. They charge you average price, not the most expensive rates. So all these things being included, just simply comparing Noble's Co-op's rates with Excel's rate will not translate into your own system after you create your own system. Because Noble's County Co-op has a WAPA allocation. You are not going to get that. Also, GRE has a very favorable financing. If they are properly doing the retail credit for their transmission line system, your rates will not get that because you are going to pay Xcel their full wholesale rate without retail credit. So that's why I hope you take all those into account when you are making your final decision, because simply comparing Noble's Co-op price with Xcel's price will not come to your benefit. My biggest concern is I don't know what is the actual number of people taking Xcel affordability program in your community. You are not going to get that program from Xcel. You have to create your own affordability program to help those people. So I hope that you have a good plan to help those people who need the help, and then create that program when you are initiating this.
Go ahead.
Thank you, Commissioner Hom. Your rate questions are legitimate relative to rates. And I can tell you, I am a rate guy. That's what I do for a living, primarily is rates. And one of the things when you sort of talk about affordability for the city, and while the CSG discussion has been interesting, quite frankly, it's not the elephant in the room. And when we talk about affordability for the city to do this, it's really about the mill rate. And I think from the city's perspective, the fact that we haven't discussed that at all is interesting. In that, you know, the 100 and we'll just round to 117 mills. And I know precedence is important to the commission. It's like 4 times higher than anything the commission has ever approved before. And there's specific items within Excel's analysis which are go in opposition to precedents. You mentioned the generation issue. The generation issue and relative to the Rochester 498 case with People's Co-op, which actually I was a part of that case. Their avoided distribution cost, which actually has a math error and minimizes that number to almost zero. Their view around what they might be able to save from a customer service perspective, which they've negated to almost nothing. The idea that the city should pay for all of the substation, even though the city only utilizes a portion of the substation. I think each of those items is incredibly important, and not only for this case, but for the precedent that's set for future cases. I can guarantee you that at 117 mils per kilowatt hour, there will never be another acquisition of a single customer in this state under any circumstances, because that's literally equal to the retail rate. If you look at Excel's testimony, their year one loss of revenue is greater than their year one revenues. So basically what they're arguing is not only won't we save money by not serving Slayton, we will actually cost us even more money for not serving Slayton. And the city feels like through the process that the detailed analysis that we submitted within our testimony has largely been ignored and not even commented on. And we think that it's not only important for this case, but for future cases that there's a vigorous discussion at this level about some of these items. And I'll leave it at that for now.
Mr. Barlow?
Thank you, Chair Commissioner Hom. I don't want to respond to all of that, but I do want to respond to something that was just said about the first year lost revenues. That's simply not the case. Our math shows that the first year that Slayton leaves the system, we will lose about $3.03 million in revenues. Our methodology treats 2.1 million of that as lost. That is obviously not higher than the amount of revenues we would have received. I just felt that it was important to get that clear on the record.
So we'll take a break, but just...
I'm sorry. Could I just respond to that before we take a break, just simply? I can point to their testimony where their year one loss of revenue payment, according to their witness, Ms. Peterson, is $3,153,021, and the revenue is $3,054,023. So actually their first year in their testimony, in her rebuttal testimony, is greater than the revenue.
So for the city of Slayton, if we adopted, just to be clear, if we adopted what the Department of Commerce overall advises that we do, that we adopt the ALJ report, would the city move forward with the acquisition?
The ALJ being 10 years at 116.79 mils and 4 point.
Yeah.
No.
That's in the record. That's what I'm having a little trouble, like, why we're going back and forth so much, because there is an ALJ report here that, and the department is saying adopt the ALJ report, just to be clear. And just to be clear, the city is saying that doesn't work for the city.
I would echo your frustrations, Madam Chair, on why we're going back and forth on all these different things when, to use the phrase elephant in the room, is very accurate. And yes, the 116.79 is
the mill
ludicrous.
Rate is the problem.
30 mils is
okay,
in the neighborhood of more usual.
We're not going to negotiate between parties right now. I just wanted to try to clarify where the different advice to the commission is coming from. And before we take a break, for the department, I didn't mean to kind of leave you out of this argument, but this dispute, is there anything that was said earlier that you want to correct, I know that the department takes complaints from consumers about CSGs, so I'm sure you will be happy to help if that is the result here. But anything else you wanted to add about what you've heard this morning before we take a break?
Sure. Thanks, Chair Sieben. We spent a lot of time talking about the CSGs. I just wanted to point out that there's only 2.5 megawatts of CSGs connected.
To the Slayton West substation?
Which isn't a great deal. In our testimony, we did provide that, and the ALJ report affirmed this, that Excel shouldn't be allowed to recover integration expenses related to CSGs, but as the conversation evolved this morning, the department would be fine with assessing engineering studies and transmission studies that are particularly related to that Slayton West substation, and appreciate Commissioner Partridge's clarification.
Sorry, I didn't track that you'd be fine attributing the engineering costs to which party?
To assessing the outcome of those studies, and then at that time seeing, which party would be responsible in line with what Commissioner Partridge had provided at the outset.
So it would, Commissioner Partridge, please.
Thank you, Chair Sieben. I think after the break, it may be helpful if Ms. Campbell could maybe provide some of her insight on the mill rate and how the department arrived at that being an appropriate amount, if she's willing.
Yeah, Chair Sieben, Commissioner Partridge, we can bring up a department witness for that, sure.
Okay, thank you.
Okay, the commission is going to stand in recess until 1 o'clock. So we'll be back at 1 o'clock. Thank you. The commission will come back from its recess, and why don't we turn to Commissioner Partridge? If Commissioner Partridge, you wanted to start with whatever you wanted.
Yes, thank you, Chair Sieben. I was hoping to hear from Ms. Campbell from the Department of Commerce on her thoughts and her process in reviewing the proposed mill rate that is included in the ALJ's report as her recommendation for us.
Ms. Campbell, welcome. When you're ready, please state your name for the record.
Good afternoon, Nancy Campbell for the Minnesota Department of Commerce.
They're not picking you up yet. That mic is bad.
Nancy Campbell for the Minnesota Department of Commerce.
Here, gotcha.
Oh,
maybe not.
Yeah.
We are getting new microphones, but not until September. We've only been saying that for like 2 years.
Is that last December?
Yeah.
At least we're not green anymore.
Yeah.
Sorry, I'm causing problems.
It's not
Nancy
you.
Campbell with the Minnesota Department of Commerce. I'll be happy to take a stab at the question that I was asked. The department, I mean, generally, I think the short answer is the department thinks that you should adopt the administrative law judge decision option 1 and some kind of a revised 10A. And I would probably make a change to the 10A that we saw modified by TUMA to get rid of the solar part and add the substation part and maybe split the engineering study costs. I think that made a lot of sense. I think that was Commissioner TUMA that recommended that. Getting into the specifics, the department, we don't have a lot of skin in this game, just trying to do what's fair. Our position was somewhere between the parties. The city of Slayton wanted 5 years for the lost revenues. Excel wanted 20 years. The department recommended 10 years. We had 2 case precedents where the commission's already decided that. The administrative law judge agreed with us on that. I think the stranded cost is the thing that was like a little bit different. The commission or the administrative law judge took a pretty strict reading, and he also, the ALJ also seemed to rely on the commission's past precedent about saying that it had to be actual avoided costs that would be shed due to the loss of the customer, and that the avoided costs must be actual, clear, and demonstrable. And that's why I think the ALJ went more with Excel's approach. And Excel's approach was 30.72% of the costs were avoidable, and 69.28% were non-avoidable for the stranded costs, whereas City of Slayton had about 2.8% of the costs being, or 97.2% being avoidable and 2.8% actually being stranded. So anyway, the department's position is kind of in the middle of these two, which to me suggests it probably is a reasonable outcome. The administrative law judge agreed with us and applied the past 2 commission orders. And that's why we think decision option 1, agreeing with the ALJ report, makes the most sense. I think we're spending a lot of time on some issues that I don't think are that big of a deal. For the engineering study, you heard that, they're going to still have the load. It's just a quarter of a mile down on the transmission line or something to that extent. It doesn't seem like that's going to be a big deal. So I don't think we should spend a lot of time on it, but that's why I think revised 10A would take care of that. And then for the CSG, for what it's worth, we think that should be a developer operator issue, and we don't think that needs to be addressed here.
Thank you, Ms. Campbell. I appreciate that, and I appreciate your review. For the city, I know you don't appear before us very often, but I think one thing I'll say of Ms. Campbell's review is that if she has looked at it and signed off on it, I know there was never a rubber stamp, and I very much rely on her expertise and advice in these situations. I did over lunch put together some modified language building off of Commissioner Tuma's modified Commissioner Part, whatever iteration it was. So here's the version 8.0 or whatever it is of this decision option, and I think it aligns with what Ms. Campbell has just said. It doesn't specifically state that the engineering study costs should be split. It would leave that up for a compliance filing, but I'm open to adding that. I can give you all a couple minutes to read over it.
And can you just talk us through what the stuff is too, like
Yes.
the new language on Slayton West substation?
Yes. So the idea here would be that I would put forward essentially the proposal in my new decision options filed on the 19th, which would be to accept the report with modifications. The main modification here is that first, it would allow for our decision today for the city to take that back, to make a decision at the council level or wherever you would need to have this conversation to decide if you wanted to move forward, understanding what the just compensation formula would look like. You could let us know how many days you would need for that, or if you needed, months, I don't know, but let us know after we've made our decision how long you need to contemplate your next steps. We would write that in, and then the city would notify Excel of whether they wanted to move forward. At that point, Excel would need to initiate the study of the Slayton West substation, and then provide us a compliance filing showing what costs are unavoidable, associated and caused by the Slayton transfer, and prudently incurred as part of the just compensation for the transfer. Put that into a compliance filing, and it would allow for parties to weigh in. I would, again, ask that the department would be willing to review that when it comes in and provide their feedback. If you need additional time, 10 days is not necessarily necessary from my perspective, so I'd like for you all to weigh in on that. The city as well would be asked to weigh in, so if you need more than 10 days, I can completely understand that. And that would allow for those additional study costs and any potential upgrades to that substation caused by the transfer to be contemplated as part of just compensation. Then the other decision options I have would be, and just to be clear, I want everybody to know we're working off the staff compiled decision option, so the numbering is different from what was in the original briefing papers. I just had a minor panic a minute ago about that. It would be 11, which is just a slight modification of a statement within the ALJ report about Excel waiving its rights. My new 14 is filed on the 19th, which is related to the burden of proof. Again, doesn't change any of the calculation of just compensation, just modifying a finding within the ALJ report. And then determining that the city, Partridge New 15, which determines that the city complied with requirements of the statute. And that would be my proposal to move forward.
One minor suggestion on your 10. I don't know if Lana, if you can get it back up. And as I was thinking through this, trying to imagine it, that I think that if the city chooses to continue to pursue the transfer, I don't want there to be an indication that they must make their final choice.
Sure.
At this stage. The final choice would be after we give them the final price.
Yep.
And so is that okay with you? Okay, good. Actually, I think that's what I was trying to get to, and I didn't clearly state it when I put my decision option together.
And commissioners might need a break to consult with staff because we didn't see this before Commissioner Partridge just explained it. But thoughts from the parties on Commissioner Partridge's new language here or her overall motion? And we'll start with the City of Slayton.
I'll let Mr. Weir answer specifically to the framing of the question. I just have a question. Ms. Campbell's number that she's referring to is the 116.79, correct? In the report, that's DOC's and ALJ's
Yes.
number?
Chair Sieben, yes. I shouldn't actually probably speak for Ms. Campbell, but yes, she is nodding. It is the number included in the ALJ report.
And then that 4 point whatever million for the acquisition?
Yes.
And that would be part of Commissioner Partridge's overall motion.
Yes. Yeah, to clarify, the motion would be to accept the ALJ's recommendation only with the modification of the 10A and then those clarifications on certain legal statements within the document.
Understood. I'm sure the other Josh has something to say about this question. I just would say prior to lunch, it seemed like we were finally heading into some in-depth discussion of what's in that 116.79 mill rate. And I really hope that we get into that before any motions hit the table, I guess is my comment.
Did the city want to make an overall statement about the remainder of Commissioner Partridge's proposal?
Thank you, Chair Seaman, Commissioner Partridge. I guess with respect to the overall context of it, I mean, well, just to start with the narrow issue first, I would say that the city would not be strongly opposed to the kind of Partridge alternative 10A. I think that that would be a relatively doable way.
And what would be the number of days you need for that's blank in the first blank in 10A?
Thank you, Commissioner Seaman. I guess I would say that it kind of depends on the rest of the motion. If it's going to be 116 mills.
Sorry, maybe we're not being clear as a commission. I think that, or as where we're at procedurally, what I was trying to ask is, or get Commissioner Partridge to articulate is, or what she did articulate is how she would modify new alternative 10A, but that's just one piece of what would be our overall decision, which Commissioner Partridge is saying her overall motion, we still need to vote on, and we want to hear from you what you think is, if we adopted what she said, like most of the ALJ report with the few exceptions that are outlined here. So the ALJ report, again, contains the lump sum initial payment, that mill rate for 10 years, and the other findings of the ALJ report, if that helps. What I'm trying to get is like, so if the commission move forward with that, then that would be our overall order that would come out. And I think what my question here then is, her new language says within blank days from today, the city you will tell Excel whether or not you want to move forward with the transfer. And so how many days do you think, if all of that happens, how many days from today do you need to go consult with the city about, now that you know what the terms would be more or less, whether you want to move forward with the transfer?
Thank you, Chair Seaman. I think that's pretty straightforward then. I mean, the city, as Mr. Malchow indicated, 116 mills would not pencil out for the city. And so that's, I mean,
So you don't care how many days you could tell us now?
In our
5 seconds.
Yeah, it would, 30 days would be more than adequate. It's 116 mills would be close to effectively doubling rates for people in Slayton, and would not be something that the city would be likely to pursue.
Yeah, no, I understand that. I think I'm just trying to, the commission may be ready to make a decision. And if we're saying these are the other decision options we're adopting, that will result in an order that will, that you may not be happy with what we're deciding on those other factors. So that's fair.
So, thank you, Chair Stephen. I would put it, there's kind of three categories, right? One is the 116 mills and things in that range where it would be an obvious no for the city. If it was 4.2 mills or something closer to our range, I think maybe 60 days would be adequate. If it's somewhere in the middle in between those two things, I think it's a closer call for the question, and it would probably require maybe some more public engagement at the city level. And so I think if we come down something in that range, I would respectfully request more time. And so
Okay, I see
somewhere between
what
30
you're trying to say.
and 120 days,
Okay.
I think would be adequate.
Appreciate that. And did we hear from the department on Commissioner Partridge's overall framing of a path forward here? I think from what I heard, it's largely, the department earlier is supportive of moving forward with the ALJ report and most of the provisions in it. So any other comments on this other language?
Chair Saban, the department's fine with the alternative 10A that's posted on the screen. As far as the burden of proof and Excel waiving its challenge, we would maintain that the ALJ has those positions. We would continue to support the ALJ's articulation of those.
So does that mean, are you okay with Partridge new 14 and 15? Is that what that was talking about?
The department wouldn't be supporting Partridge new 14.
And tell me why?
Because the department continues to support the way the ALJ articulated the burden of proof.
Okay, as it relates to that statute there?
Yes.
Okay, and if we want to, if Commissioner Partridge wants to ask more questions about that, or if you have more specificity to what particular findings it is, that might be helpful for me when I am looking this over.
Sure.
But we can come back to that. Or Commissioner Partridge, if you wanted to.
Sure. So full disclosure that we, of course, have our own legal team that helps advise us on these. And as I understand it, the new 14 does not modify any of the recommendations, the compensation, or the ultimate transfer. It's simply a interpretation of the law. So does that mean that you don't support the overall approach, or that you just don't necessarily agree on that particular issue, or that you haven't analyzed it very much?
Chair Sieben, Commissioner Partridge, I think the latter.
It's just something you haven't looked into?
Yeah.
Okay.
But overall would support your...
Okay, that's helpful. Similarly with the new 15, this just states that the City of Slayton complied with the requirements of the statute to bring the issue of just compensation forward, and that the commission, essentially, we don't have to make a determination of whether, or we are not allowed by law to really consider whether they're going to contract with a third party to help support them maintaining their utility. Again, this doesn't change the ultimate outcome or compensation for the transfer. Is more of a statement of law that clarifies something within the report. Is this something that would give you concern about the overall package, or just do you disagree or have not analyzed?
Chair Sieben, Commissioner Partridge, as it pertains to decision option 15, the department doesn't have a strong stance on that, so it doesn't change our position on the overall package.
Okay, that's very helpful for me. So 14 and 15.
It sounds like it's just like our attorneys and you, Commissioner Partridge, when you looked at new 14 and new 15, it's just a different way of stating the burden of proof.
Yeah.
Is that right? Yeah. That essentially, like, it's saying the same thing as the ALJ said for the outcome. It's just a slight modification around the which party has the burden of proof.
Right.
to determine perhaps?
I might be using this wrong, but I think Mr. Dornfeld would call it dicta. Is that right? Maybe not. Okay. This is part of the overall package, but not really all that relevant to the practicality of this.
Okay, and commissioners, if you want to talk with our attorneys about this, we can take a break for that to happen too. Sorry, you wanted to comment on Partridge, new 14 or new 15?
I did. Thank you, Chair Sabin, Commissioner Partridge. I disagree. I do believe the burden of proof is important in this case. I would zoom out to the fact that again, neither party had any Slayton-specific cost data informing any of the numbers here. And so it's critical that we consider the lack of that kind of affirmative evidence that the burden of proof has been applied to the city in this case, right? And that's I'll say a radical departure from every area of law where a claimant is seeking damages and the burden is on them to prove the damages. So consistent, we briefed this issue thoroughly, and in the general run of eminent domain cases, the city has the burden to come forward and show the petition that the city has satisfied the statutory criteria for the transfer to actually happen. But then when it comes to the matter of compensation, it's on the property owner to prove up their actual damages from the loss. It's not on the government to prove that. And so as we've submitted that burden is properly on XL, and especially with the lack of Slayton-specific data here, we feel it's really important to not put the city in an impossible burden of disproving the thing that nobody could possibly prove. And so we would respectfully disagree with the Partridge New 14.
Okay, and this isn't an eminent domain proceeding, but maybe I'm not going to get into an argument with you about that. But let's turn to the company on Commissioner Partridge's new language that she put forward that is shaping up to be like an overall decision option package where the commission would have an order coming out of this. Concerns that haven't already been articulated or thoughts on the language contained on the screen or that's otherwise new?
Thank you, Chair. Oh, sorry, too loud. I'll take this in two pieces. First, the new alternative, I don't know what version of 10A. We are comfortable with this language. On the timing for the compliance filing, we would suggest 6 months. We're pretty confident that the distribution engineering work will be done by then. If the MISO work is not done, what we would do is provide an update that's a little bit out of our control. We're hopeful that it would be done. On the rest of the package, we think there's substantial evidence in the record that would support our recommendation on the lost revenues. I know the commission hasn't been interested in discussing that today. I'm happy to talk about it further if you would like. We put in a lot of evidence to support the two changes that we're proposing, but other than that, we're comfortable with the rest of the decision options.
Madam Chair.
Commissioner Tudor.
Reviewed everything, okay? You know how this process works. You had a chance in front of the ALJ, so we have what we have in the record. And that's, I think, the frustrating thing about this. Y'all gonna want to continue to argue with each other. Argument's over. You had your chance in the ALJ. We've read all the reply comments to the exceptions and the exceptions, okay? All that evidence, trade secret, a whole bunch of stuff. I mean, it's thick, okay? So we've gone through it. So I don't know why we're still spinning around wanting to fight with each other, okay? I get it, you're not getting along and it didn't go well. I've been in litigation before too, okay? But at this stage, I'm ready. I know where I'm at. I thought the city proved their burden. I thought they met their burden. I thought their decision option was good, but I'm also open to hearing what you have to say on the ALJ. So I'm not really inclined to want to sit there and rehash it. Mr. Berg, I appreciated reading your testimony. It was very well done. I enjoyed the read, but only once. Okay, so I mean, I don't want to keep going around it again and again and again. It was it was very well laid out. I think you put a very good case together. Okay, that's where I'm at. Okay, and I know all my fellow commissioners have done the same thing, have dug into this in depth. So I don't, Mr. Barlow, I appreciate you wanting to, re-argue your case and your briefs and everything, but you had your chance. Judge Mosling is a good judge. You had your chance. Okay, and I know you have new information. That's part of the problem that I'm getting into is like it just keeps churning. It feels like I'm revisiting a past IRPs where I'm constantly getting new information at the last minute, trying to do this and do that. I got a record. I'm comfortable with my record. I think it's a good record. I think both parties have done a good job. So I don't know where my fellow commissioners are at, but I've spun through this pretty good.
Are you frustrated that you don't think that the lost revenue that is coming up wasn't incorporated into the mill rate? Because I read it as, just to try to articulate, like Commissioner Partridge laid out a decision option path that is mostly accepting the ALJ report, and that kind of, there has been a lot of record evidence that, to your point, the judge incorporated into the recommendation that we now have. And I understand that the city doesn't agree with many of the components that made up that lump sum or the mill rate, but I think for our role is to step back and be like, what does the evidence that we have now show will be fair for all parties? And it's sort of like, we can say, I thought the ALJ report was well done and made sense, from my read of it. And then it's like these issues keep coming up today.
Right.
And it's like, but then you go back and it's like, it kind of is incorporated into the record already.
Yep.
So, I think it's our job to be clear about what our role is as the commission, is to put an offer out there, which, if I understand Commissioner Partridge's motion correctly, is like mostly the ALJ report with some tweaks.
Mm-hmm.
And I get that the city doesn't think that's a great outcome for the city of Slayton. But that's up for you guys to decide then. Is this the compensation we want to pay Excel to make Excel ratepayers whole or fair? It's a fair compensation.
Right.
So I'm sorry that they're arguing too, but I think if we step back and are like, we have a good record, the Department of Commerce is supportive of what Commissioner Partridge is doing too.
And that's what I was trying to say. Yeah.
Like, I think I get that no one's happy, but what else is new?
What's new? Yeah, and I'm agreeing with you, Madam Chair. I just want to make it very clear. We have reviewed this record. I don't need to hear the arguments over and over again. Is what I'm trying to say. It's a close call. I mean, I think a close call in my mind. I do view Excel a little different than what Peoples in Rochester would be like. That's why I don't know if I'd weigh much on that precedent. I think Excel as a vertically integrated utility has ability to move its investments around more robustly than would Peoples down in Rochester would have been. But it's really not apples to apples too, because it was only a partial takeover. And so we're not looking at a whole substation move. And so there's a lot of things you can go both ways. Now, if I were sitting in the judge's shoe, and I want to make that very clear, if I was sitting in the judge's shoe, I probably would have said that the city met their burden. I would be comfortable with what their recommendation is. But again, I think it's an extremely close call, and I would not necessarily go against Ms. Campbell too, because she understands the finances far better than I do. So that's just kind of how I fell out on it. I mean, I'm not, the way the Partridge motion is right now, I don't think I'd vote against it. So I mean, I'm just struggling with, it's a close call.
Because of the payment, or because of that's what I'm not tracking what you're saying.
Where a close call is that I don't think they don't have they're not in as difficult of a position under this statute to figure out their lost revenues. Their lost revenues is the thing the legislature put in there to keep it from becoming a game. okay, where utilities are getting played by the munis and back and forth and back and forth. And so that was their barrier. And so in analyzing it, I would have been a little bit more lenient on that number. I probably would have leaned more towards where the city was at, just because I think Excel has the ability to move assets around a lot more efficiently than, say, Peoples would. That was what the department's argument was. We have a precedent. We're going to run with the precedent. That puts us at 10 years. That was fair, and that was their analysis. I would have probably muddled around with that 10 years a little bit if I sat as the judge. I'm not the judge right now. I have to determine whether this ALJ report and Commissioner Partridge's motion is sufficient, but I'm just saying I struggled with it. I mean, just because I view the way Excel can handle their lost revenue and Peoples would have been two different things, and I probably would have looked at 10 years versus 5 years a little differently. But I have right now in front of me 10 years, and so I have to now make the tough decision, is that a good outcome with all these other changes?
Sorry, I didn't mean to put you
No,
so
no.
much on the spot, but it is, and I know you want to say something, but I'm just talking to the commissioners right now. We have to make a decision out of 5 of us independently, and we don't get to talk to each other about it. So this is why,
You just heard our conversation we would have had from the legislature back in the back rooms.
but we can't do that. So that's why I'm trying to just see where my colleagues are to kind of like try to help us figure out what we're going to do. So I'm not trying to be disrespectful. I'm trying to hear where my colleagues are because, like I said earlier, this is new language and we're all kind of trying to figure it out on where we're comfortable with. Commissioner Sullivan, do you want to think about things or say anything now or have a sense of where you are that would be helpful, or Commissioner Hom? Commissioner Hom?
Thank you, Chair Sieben. Yeah, I sometimes this is very counterintuitive, but I think that typically our utility has a large capital investment and a lot of the operation has economies of scale. I think that's why they have a monopoly and we have that regulatory compact. That's why sometimes you just do the simple accounting calculation that doesn't meet this number based on economies of scale. So that can make things being difficult to understand sometimes. So that's why I don't think we need to go into more detail. I agree that I think a record is records, and based on this record, I can make a decision today. But I understand the frustration by city that simple accounting number sometimes doesn't meet these overall lost opportunity plus, which is opportunity cost concept, and then economies of scale. That number is very confusing numbers. But I think it's a well-founded economic number. I think that's why I can make a decision based on today's number.
I mean, if I were to write the statute, I would have wrote it to say, the munis, you just pay the depreciation cost, the cost after depreciation, okay? But you must become a muni, okay? And you must stay a muni for X number of years. You can't go in and out, in and out. And I think the legislature creates that lost revenue as kind of the stopgap so that they're not just grabbing, deciding, oh, we're going to go with Otter Tail this month, and we're going to go with Nobles next year, and they needed to put something in there to keep that from happening. That's where I strongly disagreed with Mr. Barlow. I'm glad you didn't raise it up on, the fact that they have to be a muni. I don't think they have to under the law, but that's just irrelevant. But that's when I looked at it, I said the legislature put that in as the guard, and now we have to interpret it, which is not an easy interpretation, as you just pointed out, Commissioner Hom. And I do put a lot of value in how Ms. Campbell looks at these issues because she has done us well over the years in rate cases, and so that it's a lot of this going on. So,
Commissioner Sullivan, and then we'll take a break.
Right now I'm ready to go. So I don't have like any hot take or for a vote. I don't have any hot take or anything. I'm just.
You're ready to vote on Commissioner Partridge's motion?
Mm-hmm. Yep.
In support of it?
Well, we can wait.
Well, I mean, this is my job
Yes,
to see like where we're
I know. I
headed.
just.
So I'm putting
No,
you on the
I mean,
spot.
no, it's fine. And I mean, I reviewed the ALJ's decision. I kind of said where I was at before from the jump that, I was in the blend between, the longer term generation costs, distribution costs. I said 15 years. So actually, the city probably wouldn't want to hear it, but I'd have probably a little bit higher mill rate for the reasons that Commissioner Hom was mentioning. I do think these economies of scale, they can obfuscate, or they can make it look like it's less expensive than it actually is. And so, I mean, I'm ultimately, I'm frustrated at the whole situation. And I think that the city, has been put in a bad spot. And, but the numbers are the numbers. And I know the city disagrees with the numbers, and I know they'd rather have had us talk more about it today. But I can assure you we've reviewed the documents, and we've reviewed them and thought them through. And the conversation that you heard here, like Commissioner Sieben had said, is these are the things that we have to hash out between us, and we have to have that conversation between these issues are, we have to see where everybody's at. But I mean, I'm ready to go on the underlying decision, so.
Okay. I just want to talk to the attorneys about the burden of proof issue one more time. So we'll need a few minutes to do that, and then we can come back from, how about in 10 minutes from a recess? So the commission stands in recess. The commission will come back from its recess, and Mr. Black, I understand you wanted to address the commission briefly, please.
Yes,
And
thank-
state your name and the organization you're representing for the record.
Thank you, Madam Chair and Commissioners. My name is Bill Black. I'm Government Relations Attorney for the Minnesota Municipal Utilities Association. I just wanted to state real briefly that the impact of this decision may be much wider than we are all talking about. Whether or not Slayton does municipalize, the impact on municipal utilities' ability to grow with their cities could be devastated with a precedent of 116 mills.
Okay, Mr. Black, is this information or are you a party in the record?
We did not file to be
Yeah,
party
then
to
I
record.
think at this point, like,
Thank you, Madam Chair.
you're
Understand.
kind of like blowing us up in a way I'm not really comfortable with. So we appreciate that you always had time to file comments into the record and could have petitioned to be a party, but I have a feeling that if I let you keep talking, someone else is going to be really angry at the commission, and then we're going to have other issues to have to handle. So thank you, and my apologies for saying you could speak and then cutting you off. Commissioner Partridge, on your overall motion and the legal issues that you discussed with staff on the break, could you provide comments, please?
Thank you, Chair Sieben. So I am prepared to make an overall motion. I will be making a modification to what I had initially said, which is that I will just remove my new 14. I think that the bottom line is that under either burden of proof, the result is the same in my mind, that we have sufficient information into the record to make our decision, and that we, as a commission, don't really need to weigh in on that particular item.
So you're striking, your overall motion would not include Partridge new 14?
Yes, and I would like to give a complete overall motion when you're ready, Chair.
Yes, thank you.
You ready?
And
Or do you wanna-
are you working off of your, off of the briefing paper?
Yes.
Okay, or is it going to be
Well-
on the screen? I don't, the new language maybe too?
Yes, thank you. Ms. Patterson, if you would pull up the new modified 10A. Okay. And then my proposed motion would be working off of refers to staff's compiled decision options from August 16th, just noting that those numbers are different than what was in the briefing papers, so I apologize for that. And then my own filing dated August 19th. So sorry for two different documents, Chair. My proposal is adopting decision option number 3, which is to accept the ALJ report with modifications. The modified 10A that is shown on the screen, noting that we do need some number to fill in here for days after this decision. Decision option 11, which is to determine that Excel has not waived its right to dispute the property sales associated with the transfer. And then Partridge new 15 is determined that the city of Slayton has complied with the requirements of statute 216B45 to bring the issue of just compensation before the commission. And to the extent that Excel argues the city's proposal does not constitute a municipal utility, 216B45 does not direct the commission to make that determination when a utility objects to acquisition of its property. So that is my complete motion. Again, 3 modified 10A, 11, and my new 15.
And since I was the one that put 10 forward and listening to the conversations, I understand what the city's response was, but I think we should put 30 days in there just to give time for discussion, but I do hear what the city's saying.
And for the department, earlier you said you didn't have strong feelings about Partridge, new 15. And Commissioner Partridge is not moving new 14 anymore. And so could you comment on both of those? I assume you're fine then not moving new 14, but what about Partridge, new 15? Did you have any time on the break to think about that more?
Chair Sieben, with new 14 being removed, that was the major concern that we had. 15 wasn't as concerning. As far as
so you're fine with including Partridge, new 15?
Yeah, that's fine.
Okay, great. Sorry, something else?
Decision option 11, we didn't support that. We believe Excel has waived its right to procedurally challenge.
Tell me a little bit more about that, because my brain wasn't focused on that.
Sure.
I'd suggest not, but that's okay.
The department believes that Excel has waived its opportunity to procedurally challenge waiver, and that's because we've endured an entire contested case process, and there's been ample time, and Excel's continued participation has waived that.
And Mr. Barlow, on that number 11?
Thank you, Chair. We're fine with decision option 11. I don't, like, we have been objecting. I understand the commission's going to move forward. I'm not trying to make an argument about that, but I don't understand how you could find that I'm sorry, I don't really understand Ms. Hundel's analysis, but we're comfortable with 11. We don't think it's critical to the decision. And it largely restates what we've been saying in the case.
And Commissioner Tuma, what were you saying about it?
I'm good, Madam Chair. I mean, we can get into it, but we really don't need to. I just don't think it is our business, simply put. I mean, it's just not. The legislature put in the way the statute is to be read. If you read it, it's very clear. They say municipality and don't say that is going to become a municipal utility. It just says municipality. And that's very clearly defined in the statute, and they use in 216B municipal utility multiple places, so they obviously knew the difference. So I don't know why we're even delving into this issue at all. I mean, it's outside of our jurisdiction. If they want to go to the legislature, if they think they have an action in court, which I don't think they do, they can deal with that. But in front of us, we have a statute. There was a petition in front of us. We need to determine what the fair value is for this municipality, and that's what we're doing.
So you just assume leave decision option 11 out? Is that what you're saying?
I just don't think it matters. So I'm fine with it in. So
You're fine with it in?
Yeah.
Okay. Any other commissioner want to comment on the overall motion? Are parties ready to, or are commissioners ready to vote on the overall motion? You're clear on what it is?
Yeah, can I just make one statement? I do want to just say that the job of the commission is to look within the record and review the record, and we cannot, on the fly and on the bench, start coming up with new numbers and negotiating new numbers with parties. And so we are making our decision with what's in the record. And I just wanted to reiterate that. I think it's been stated multiple times, but this commission has to review what's in the record and work with the numbers and data that we have. And I have nothing else that I wanted to add.
Okay. On Commissioner Partridge's
Can we just restate it really quickly?
Yeah. Decision option 3. The modified 10A, 11, and Partridge new 15.
And just to be clear, the department, you're supportive of the overall motion? Yes, she's nodding. We got that before. The city of Slayton, we understand you don't like the motion overall and you're opposed to it, correct?
That's correct, Madam Chair.
And Excel, on the overall motion,
Thank you, Chair. We would have recommended some different things, but we understand the motion, and I'm not here to raise a bunch of objections at this point.
Seems like the commission's got it vote right.
That's what it comes
Everyone happy. There we go.
Okay, well, everyone's clear on what the motion is, and we'll proceed to vote on Commissioner Partridge's overall motion. All in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you very much, everyone. We have a lot of people who have been waiting for dockets 5 and 6 in the back, so we'll get started on docket 5 as soon as folks get in place. Thanks for your patience. It's a little bit after 12:30.
Yeah. Well, it's before 12:30 in Hawaii. Man, Dennis and I thought we were going to get you up here earlier. I saw you hiding in the back there. Good news is Mr. Barlow didn't throw you under the bus, so.
No. I still have a chance to do him on things.
Go right ahead.
Mr. Duran, please introduce item number 4, or 5, I mean. Let's not do 4 again.
Yeah, hopefully this one's a little simpler, but we'll see. Good afternoon, Chair Sieben and Commissioners. Item number 5 is for docket number E999/CI-16-521 in the matter of updating the generic standards for the interconnection and operation of distributed generation facilities established under Minnesota Statute 216B 1611. The question before the Commission is, should the Commission approve the technical subgroup's proposed changes to the MNDIP and the TIIR regarding battery energy storage systems and limited/non-export systems? There were no late filed comments or decision options. Staff has no further remarks, but is available for questions. Thank you.
Okay, thank you. And we weren't going to have opening comments, right? First, before we begin, and I'm sure other commenters will, or other commissioners will say this, but I wanted to really thank all of the parties, and especially you, Mr. Duran, for working through so much of the stakeholder process that has led to this good outcome. I know it's been a ton of extra work, and you were, very Minnesotan in saying, no, it wasn't me, it was other people, but we know that you did a ton of work, so.
He's learning. He's from Arizona, too.
Yeah. Thank you very much, Mr. Duran, for all your work on this item, and not just in preparing the briefing papers, but the work for the technical subgroup, too. So we appreciate that. So Commissioner Hom, excuse me.
Thank you, Chair Sieben. I concur with that. Yes, as a lead commissioner for the DGWG, I watched how Mr. Duran was working on this issue, and a lot of people doesn't see what he's doing behind the scene on this kind of work, and I think we should give him a lot of credit. And also, I really respect all those working group participants. I think it is a lot of work. But also, as I said during the meeting, and I think time is essence. We need to move on quickly as soon as possible So if there is any small difference, we better move on. And if you can fix it, some small difference later, we can do it later. Being said, I think I really appreciate all the participants of the DGWG. And then also at the one point, I think the DGWG member was able to bring former Commissioner Matt Sugar to the table, and that was very helpful. Being said, I don't have any specific question, except I have some possible motion, so I can ask party about that. That might be more productive rather than I do the Q&A. So I'll make a mock motion and then see what reaction we are getting from the party. So at this time, I'm thinking about moving decision option 1, 3, 6, 8, 11, 12, 13, and 16. And then I can ask parties whether that's acceptable or not. And so let's start with easy target, Mr. Heinen.
Good afternoon, Chair Sieben, Commissioners. Adam Heinen with Dakota Electric Association. Overall, Commissioner Hom, draft motion is not objectable to us. A couple items, 3, we had, decision option 4 would be preferred, but I think, we can live with decision option 3, especially if we have a little more discussion around the insurance question. And then, I think that we're okay with the entirety of the motion.
Okay, thank you.
Chair Sieben, Commissioner Hom. Oh, it's a lot louder than
It's off. I can see it.
Not your fault.
We'll try that again. Or not.
And state your name too, Mr.
Yes.
Bodine.
Chair Sieben, Commissioner Hom, Matt Brodeen with Minnesota Power. Overall, support the motion. Just wanted to note as well with, I believe it was decision option 3, Minnesota Power actually would prefer decision option 4 as well. And that one, the 40 versus 50, for similar reasons to what Excel and Dakota indicated. And also, I've been told by our technical folks as well that moving from 40 to 50 for kind of a standard contract throws in a little bit of a complication because you can do a 200 amp board for a 40 kilowatt, but as soon as you move to 50, there's a requirement to move to 320. So there's just a little bit more complexity on our end as far as that limit, that number right there between the 40 and 50. But it's something we can work through if need be.
Thank you. So my question along the line is, it's not about the engineering reliability issue. So it can be dealt through your contract with whoever is trying to do. So that's why I'm more comfortable with the bigger, larger size than smaller size. It might be more convenient with the 40 because you already have the system. But if anybody wants to do 50 with paying extra because of a certain engineering issue, it is up to the party who wants to do it. So that was my rationale there.
Mr. Dennison.
Thank you, Chair and Commissioner Hom.
Your name?
For Xcel Energy, sorry. The overall motion, I think, is generally fine. We share softly the concerns that Minnesota Power expressed on decision options 3 and 4. The only thing I do note is decision option 13 would be, having a work group to discuss changing, having an addendum to uniform statewide contract. If that moves forward, that would require a change to the rules to be reopened in the rulemaking. So I want to make sure, but that could be discussed at the work group. Just want to highlight that. Thank you.
Sydney Lieb with the Minnesota Department of Commerce. Commissioner Hom, could you, was it 8 and 11? I just want to make sure I heard it correctly.
It was 8.
Yes, 8 is in that package and 11 is in that package.
Okay, and nothing additional after 8, right?
No, there is no modification, nothing, so.
Okay. Then the department, it has no concerns with the draft motion.
Thank you.
Steve Coleman, I was an independent, individual participant in this. I agree with all of the motion, except that I do prefer option 5 over 6, and would believe it would encourage more clean distributed energy resources, and looks forward to availability of export capacity, which was not there when the interpretation was more of a nameplate capacity. So I think one is looking to the past and one is looking to the future. But I appreciate your motion.
Mr. Zahn.
Madam Chair, Commissioners, Curtis Zahn on behalf of MNCEA. And I want to recognize, too, Mr. Duran and IRAC for really helping out with this process. I thought it was absolutely fantastic and was happy to be a part of it. We support 1 and 3. With regard to 6, 8, and 12, our concern would be that it's inconsistent with the clear statutory language. We support 13, and I would disagree with Mr. Denniston that doing an addendum for the uniform statewide contract requires rulemaking, because that's the whole point of it, is to avoid that. We wouldn't be changing the uniform statewide contract. And obviously support 16 as well. Thank you.
Thank you.
Any other questions from commissioners?
Mr. Dennison on
Madam-
6. Oh, sorry, there's somebody online.
Oh, sorry,
That's right.
we forgot Otter Tail. Hi, Mr. Stephenson. Please state your name for the record.
Thank you, Madam Chair. Kerry Stephenson on behalf of Otter Tail Power Company. I just wanted to make sure that we noted in the record that we do support Commissioner Hom's motion.
Thank you. Commissioner Tuma.
I'm just going off my notes, Commissioner Hom, and it's Xcel Energy suggested 6 in the process. And I had in my notes, we don't need really take action on this. So what is the desire that we actually modify 1.1.1 to clearly indicate that it's 10 megawatts of name capacity? Because I thought that's what it is now, and that's what my confusion is, why we need to state that the sky is blue. But help me out. I might be missing.
Sure.
That's my notes.
Thank you, Chair and Commissioner Tuba. Some people, even though I think the sky is blue, some people in the work group were saying it's a different color. And therefore, in section 1.1.1, we think it's important to create the additional clarity to insert the word nameplate before capacity.
And I think that's where we're going. And I guess I didn't want to, what that looks like. And I get your argument that, if you look at Flint Hills, it would have been under the DERS the way they're building it. I get that argument. But shouldn't that be a charge to the working group to figure that out, as opposed to just saying it's 10 megawatts, we're done? That's what I'm worried about. We're saying it's done.
No. So thank you, Chair and Commissioner Tuma. So with Flint Hills, they have a 45 megawatt solar facility. We processed that application. We use MNDIP as a guidepost to what to do. And then we filed a MNDIA as modified with redline changes to have the commission approve that, end up being approved on the 30-day negative checkoff. So our understanding was that MNDIP applied had a 10 megawatt nameplate capacity cap. We still use that to inform us on how to process other applications that exceeded that. You mentioned Flint Hills. We've also done some with the University of Minnesota that are of public record.
Okay. In the department, you were thinking differently? I mean, you seem to be comfortable with things, where things are at. I just want to pre-decide that we couldn't do something more along the lines of what was being suggested by some folks, but I just want to pre-decide it here. I didn't think I'd have enough information. So where are you at as far as 6 is concerned?
Dr. Lieb.
Chair Sieben, Commissioner Tuma, we prefer 5. We don't have a strong opinion on this one. I think this is the Minn dip. This is not about the export capacity versus nameplate discussion that's going on related to net metering rates. And those two things are completely separate. The department recognizes as a policy position on the Minn dip, there's potentially value in citing it as export capacity because it would encourage people to have larger systems behind the meter for self-serving electricity. And it acknowledges that we have technology advancements that allow the export capacity to be metered such that the system impact, which is really what the Minn dip is protected at that 40 kW. But it's a policy decision, and I don't think we have a strong feeling either way, but we think generally if we had to pick, we would choose 5.
And Commissioner Hom, that's what the concern I was just trying to understand where to go with this. I didn't want to prejudge kind of where we go with all this because there are other things happening in this space. So I guess I had no action on 5 or 6, but I was just trying to get your understanding of what you're thinking.
Yeah, thank you, Commissioner Tuma. So, yeah, I think a lot of discussion going on. There's a definition of capacity in many different places. So that's why, for now, I think we can move on quickly. That's why I mentioned that at this point, nameplate capacity will make these things faster. So that's why that was my rationale. But if party has a very strong position, we can deal with it in a different way. But I think that may take more time. And if he don't make a decision on this one, we may have to send it back or we go to the other direction. I don't know how strong utility will react to it. So I think that's why I try to move it quicker. Sooner is better than trying to precisely making that final decision.
Well, that's helpful for me because I just want to make it seem like we're making a final judgment on where this ends up, because a lot of the debate we're going to have is over what should be the technology and how we determine the technology and what is available to the grid versus to held behind the meter. A little bit of discussion, kind of what we're having up in Upper Sioux. What are these devices and how are they working? And I just don't know if we're at the point of final decision, but it helps me to know that we're just trying to keep things moving fast, and that's helpful in not making a final decision.
Any other questions from commissioners? Then Commissioner Hom, will you please renew your motion?
Thank you, Chair Sieben. So I'll just repeat my original draft motion. That is 1, 3, 6, 8, 11, 12, 13, and 16.
Is there any discussion? All in favor, please say aye.
Aye.
Aye. Opposed? The motion prevails. Thank you, everyone. That was quick for how much work went into that. But we appreciate it very much.
Oh. MPIRP. Annie just sent it. The MPIRP. Oh, no, this is, yeah, here it is.
What did they say?
Oh, this is the preliminary packet, so it's not the whole thing. Okay.
Yeah, it wasn't supposed to be till next week. I think I got it.
Ms. Brown-Huss, please introduce our last agenda item for us.
Good afternoon, Chair Sieben and Commissioners. Item number 6 is docket P407, 405, DTL 26-266. In the matter of Frontier Communications of Minnesota and Citizens Telecommunications Company of Minnesota, LLC, for approval of the proposed customer transition plan. The question before the Commission is, how should the Commission proceed with Frontier Communications of Minnesota and Citizens Telecommunications Company of Minnesota's proposed customer transition plan petition? A late file letter was received from Frontier Communications on August 18th, and Commissioner Tuma filed new and revised decision options on August 18th. Yesterday, Wednesday, staff filed revised decision options. Hard copies of the compiled late filed decision options are available in the back of the room. I have no further remarks, but am available for questions. Thank you.
And Ms. Brown-Huss, were we going to have opening statements from parties? Or maybe just ask them, sorry, I didn't have a note here. So if the parties can come forward, we'll begin with, please, if you could identify yourselves and then state your preferred decision options given the late filed ones. That would be helpful. Who would like to begin? Mr. Barlow?
Thank you, Chair. My name is Ryan Barlow from the law firm of Cozen O'Connor. I'm representing Frontier and Citizens. Also today, representing the same group is Dan Kahn from the law firm of WBK. He's available remotely. And in addition, we have Paul Vasington from Verizon, the parent of Frontier and Citizens.
Ms. Hinderly.
Good afternoon, Chair Sieben. This one's really loud. I'm going to back up. Catherine Hinderly on behalf of the Office of the Attorney General, Residential Utilities Division.
Amrit Hundle, representing the Department of Commerce.
And, sorry, I don't have everybody's name in front of me, but folks online who are representing parties, I can't see your names. If you could each identify yourselves.
My camera's not working, unfortunately. This is Carson Turnquist. I'm the president of Local 7270 Communication Workers in America. I represent the telecom technicians in southern and western Minnesota.
Great.
Good afternoon, Chair.
Go ahead, Dan.
Good afternoon, Chair and Commissioners. My name is Dan Kahn of the law firm Wilkinson Barker Nauer, and I'm here on behalf of Frontier and Citizens.
And I'm Paul Vasington. Last name is spelled V as in Victor, A-S-I-N-G-T-O-N. I'm a Senior Director of Regulatory and Government Affairs with Verizon, which is the parent company now of Frontier and Citizens.
Okay, and just for clarification though, Mr. Barlow will be your primary spokesperson for both you, Mr. Kahn, and you, Mr. Vasington?
Correct.
Okay. Is there anybody else we missed? Okay, then, Mr. Barlow, please comment on the decision options.
Thank you, Chair. Commissioners, I hope you had an opportunity to review our letter that we filed a few days ago. We filed it in the hopes of narrowing the issues that needed to be resolved at this procedural hearing. We continue to recommend the decision options outlined in there, which would be the modified version of 8 that we provided, and 7, 9, and 10. And with that package, we're comfortable with decision option 2 as well.
And Ms. Hinderly.
Thank you, Chair Sieben. The OAG is supportive of modified TUMA 2, modified TUMA 4, and modified TUMA 7, both A and B.
And for the department?
Thank you, Chair Sieben. The department supports modified TUMA 2, modified TUMA 4, and modified TUMA 7, A and B.
Mr. Turnquist?
Yes, ma'am. I have not seen yesterday's publication, so I can't really speak educated on it.
Okay, no problem. Commissioner Tuma, why don't we turn to you then for questions to the parties?
Yeah, let's start with if you could put up the statute. I just wanted to walk through it with Mr. Barlow, understanding this is novel, and we're starting it, and I appreciate how you've laid out your decision option. I just wanted to be clear kind of how I'm proceeding in my mind at looking at this statute. And what was critical to me, this statute is pretty simple. We're just trying to assist copper. That's the only people that are going to be named here. Copper people who are still on copper, grandma, and people who just haven't got rid of their copper lines, okay? And we're trying to mitigate them to broadband or maybe wireless. That's what I was trying to get myself around. And it's basically to let you get out of the obligation to serve. It's just there is a change in the telecom world. We had an opportunity to be with Mr. Fournier today, and he's seen it all from the beginning to the end. And so we're in this transition of moving it. And central to that is the definition of alternative provider. It seemed to be critical to our state statute. And so I put it up here. Alternative provider is one or more providers the Federal Communications has identified through the broadband data collection. And so I delved into that. If you could go to the next slide, I gave you, Lana, on this. And so I tried to understand what that was. And so here it is. FCC has this document. This is right on the FCC website. It's 4597 Delancey Court. I don't know if I want to announce that too much, but that might be a goofy bohemian who's working on a shed in his backyard. And if you could just kind of zoom in on the right-hand side. This is data that the FCC has been collecting. You scroll down so you can see all the providers that goofy bohemian would have potential that say they can serve us. And so this is data that is being collected by the FCC, has been collected over the years, I think in part to start getting to this transition, Mr. Barlow. And I see that I have, my son would not have let me get off of Spectrum because I get 1,000 down and 35 up, okay? Everybody else is not even close, okay? But they're fixed wireless, some of them satellite. I have a few that would qualify. So go back to the statute. And so what the statute for providers says that successor data for a wireline broad-based access service through fiber optic cable to the home, 25 down, 3 up, and then there's 120% of the cost. So this data is essentially out there of all these providers, okay, that I could qualify for. And if I still was on copper, okay, Verizon, who was my provider, could come to me and say, we're going to take you off and you have Charter there and or Spectrum now. And so you would be, you'd be someone who qualified to be removed from the copper system. But then there was this or that caused me a little bit of confusion, and I want you to clarify this, or a request by a telephone company or telecommunication carrier, okay, the Federal Communication has approved adequate replacement provider who meets the requirements of this section. And if I'm reading that statute correctly, Mr. Barlow, if I didn't have Spectrum, I would still, if one of those providers requested to be named an alternative providers, which is critical to the statute, that's all you have to give people notice of. If one of them would notify you, okay, that they were wanting to be a alternative provider in your plan, okay, then I could still, even though I don't have Spectrum, I could still then would be a copper person who could essentially lose my copper service under the plan. Is that a fair interpretation of how this works?
Mr. Barlow.
Thank you, Chair. Commissioner Tuma. Yes, I think I agree with everything that you said. I just want to provide one clarification. Our petition is based entirely on Part 2 of that statute. We have filed a simultaneous petition with the FCC asking for approval as an adequate replacement, certain locations in Minnesota and in other states as well. When the FCC approves that, it will satisfy the requirements of Provision 2 for those locations.
And so that's what I'm getting my head around. You can stay right there, because I'm struggling with our responsibility. Because you filed a petition. If you look at my new 2, okay, Mr. Barlow, those words should look very familiar to you. I just took your first paragraph of your petition and I put it in a decision option. Okay, it's your application to us under a state statute. And so I'm trying to apply that state statute. And when I read that state statute, one of the requirements, a customer transition plan, is clearly identify the alternative providers to customers in the affected area. It didn't say just one. It doesn't say all either, okay, but I think it applies all who have requested. And so even though you may want to get that approved by the FCC, if Starlink or AT&T, which 25.3, I mean, just barely qualifies, says somewhere we request to be on the alternative provider list, they should be on the alternative provider list that you need to make clearly identified for all copper customers. That's the way I read this law.
Thank you, Chair. Commissioner Tuma. I don't think that's quite how it works, in that when you file a petition to the FCC, you only need to
Not
file.
filing a petition to the FCC, you're filing a petition with the Minnesota Public Utilities Commission under the Minnesota statute 237.181. That's what I have in front of me now. And so I'm reading this language, and it says a request by a telephone company or not by the petitioner, not by the applicant, a company, okay? And I have several companies that would qualify if they want to be an alternative provider. So that's what I'm struggling with. I mean, this is the Minnesota Public Utilities Commission. The last place I want to be is FCC. So God bless you all that have to do that. But
Thank you, Chair. Commissioner Tuma. And if we get a little bit deeper in the FCC stuff, I'm going to call on Mr. Khan for support. But I think I can answer your question. The way that I read this language is when a telephone company or a carrier files a request with the FCC to be designated as an adequate replacement, that's on a location-by-location basis. So like this location, Frontier has filed a petition to identify our adequate services at that location. The only people who will file that are entities that are currently providing copper service to those specific locations. No one else would file an adequate replacement filing for locations at which they don't have copper. So what our petition is that we have asked the Minnesota Commission, we're saying these are what we anticipate will be our adequate replacements approved by the FCC. Under state law, those will be the alternative providers for which we are moving forward. And so that's what we have identified in our petition.
Ms. Hinderly, help me out. I mean, I was reading your stuff. It seems like you think it's a little broader than that. And I can't remember which one. I was Mr. Turnquist or somebody said you need to list all. And I'm trying to, I don't think you have to list all providers, but I think you have to do all alternative providers under the definition of the statute. That's what I'm seeing, but you can correct me if I'm wrong.
Chair Steven, Commissioner Tuma, I would disagree with Mr. Barlow's interpretation because I believe, first off, it would read out that last phrase that you have highlighted in blue, which is meets the requirements of this section. So it might not have looked like it from the outside, but this statute had a very long and vigorous debate behind the scenes at the legislature, and ensuring that the Minnesota Commission continued to have some reins on FCC determinations was one of the things that many stakeholders felt important to preserve. And what we landed on was meets the requirement of this section so that the Commission could determine, even if it's approved by the FCC, does that meet the requirements, that you have highlighted in 1, which is off the screen right now, about being, 25 down, 3 up. In terms of what information needs to be provided in the petition or to consumers, I agree, it doesn't say alternative provider, singular, it doesn't say all. And I think the commission has some discretion as the expert in this area to determine what level of alternative providers that it believes is necessary for customers who will be losing their telephone service to be provided with so that they can continue to have reliable communication in order to call their loved ones, access 911, have their home alarm systems work, et cetera. So I think that you have some discretion to determine what breadth alternative providers should be provided by the company.
Anything to add from the department or?
Ms. Sondel.
Chair Sabin, Commissioner Tuma, we agree with the phrasing that Ms. Hinderly provided. We don't believe that every single alternative provider needs to be provided in order to have a complete application here, but it's within the commission's discretion as to the number of alternative providers. The department wants to avoid a situation where a lot of that searching for alternative providers falls on the customer.
And I don't know what the FCC is intending by their order, but I think our legislature intended informed copper customers so that they have the options that are in front of us, because it's going to get changed suddenly on them and they need to make a decision. Otherwise, they might not be able to call 911 or their grandkids. I mean, I think that was the intent of the statute as I read it, and I agree with you on that. I'm not going to delve too far because we're pretty exhausted already, if you haven't determined that. But I do want to talk a little bit about process. And so what I tried to do with 4, Mr. Barlow, was to create a flexible process for the parties to sit down before September 11, or September 10, I should say, and figure out what information needs to be in the record. I don't know whether there's trade secret information in that, but I think what I was trying to create here, because I do give you a chance to explain if you don't agree with some of this, and you've tried to explain some of it already, but this is preliminary. We're just setting up a process. And so what I thought by doing the modified 4 is that I'm hoping that you all can sit down, and that's this question I'm going to ask you, to sit down and kind of get the scope of what the discovery is going to be and what it's going to look like. If it gets into trade secret, we got a process, okay? If Mr. Turnquist wants to be a party and an intervener, I would hope you include him in this discussion now, but I would encourage him to intervene in this. I was trying to find a short way of doing it, but our attorneys very well corrected me that I couldn't do a shortcut on interveners. They have to petition, and anybody could object. So I would hope the workers join as a party. But so, Mr. Barlow, I put number 4 in there. I know you had number 8, and you wanted to kind of get onto your list of things you wanted to provide. But I think I want to have, at least you have a discussion with these folks, and maybe your list is the list. Okay, I did a side-by-side. There's a few things I probably would have added that I like with theirs, but I kind of want you to have a conversation. So before Labor Day, are you willing to sit down with the parties and the workers to identify a discovery process that you can tell us what it's going to be by September 10?
Thank you, Chair. Commissioner Tuma. Commissioner Tuma, I have to say I'm trying to catch up because what you've just described doesn't match with the filing process that I see outlined in option 4. If you're asking us if we'll sit down and have a conversation with my colleagues at the department and the OAG, we're happy to do that. We've already met with them on this case. We're going to continue to be engaged. What the language here looks like to me is that we would make a filing, and I can represent that the information that we would provide is the information that we've listed in our modified decision option 8. And then there would be, it's not clear to me what would happen next, but if that turns into an extended dispute with multiple rounds of filings and we're still not
That's my concern, okay, Mr. Barlow, is I'm trying to give you an opportunity. Yes, you're to file something, but my hope is that you would sit down with your folks and say, look, I agree with you on this, but I can modify it by this, and you have a conversation. On September 10, we're flying. We're on our way, okay?
Commissioner Tuma, we're happy to have that conversation. I just want to be real direct, though. I don't know that we're going to reach an agreement that's going to resolve all
There's going to
issues.
be an objection, and then we'll come back here and try to figure it out, because we're trying to do this expedited. So in other words, it's not in front of an ALJ, okay? It's going to have to come back to us in some fashion, okay? And I'm trying to speed things up. So I'm not too excited what I'm hearing, but Ms. Hinderly, you okay trying to sit down and see if you can work out a discovery process so that you can get the information you need to be able to analyze this filing?
Yeah, Chair Stephen, Commissioner Tuma, I'm a little troubled by Mr. Barlow's pessimism. I think that our intention here, certainly as the OAG, is not to be in any way disruptive of trying to meet the goals of 237-181, which frankly are very similar to the goals of the FCC's network modernization order. It's to allow companies to exit copper in a way that is safe and preserves essential services for people who don't have an adequate alternative. I know from the OAG's perspective, we are very willing to think creatively about how we can most efficiently get people the information they need and get us and the Department of Commerce the information we need to ensure that folks have an adequate alternative. I hope that Verizon is willing to work with us on that. I think that none of us want to be in a situation where we might be in several months if this is going slowly. So we certainly understand our obligations to try to get this to work. And I hope that Verizon considers very strongly that we are willing to work with them. And we don't want a situation of this dragging on for a long time either. So I hope that they will reconsider working with us to get us the information we need rather than insisting on modified decision option 8 if we meet and prolonging a dispute about this.
Ms. Raymond, anything to add?
Chair Sieben, Commissioner Tuma, the department is more than happy to discuss further with Frontier.
And then Mr. Turnquist,
Yes, sir, Commissioner Tuma. I agree with a lot of what you're stating. My biggest concern is most Frontier customers, other than the South Metro or the Twin Cities, are rural customers, where the reason they're still on our DSL and our voice services is because it's the only option. I guess what I would like to see, if possible, is just a little more of a plan, what's going to happen with those customers, because cellular is not an option in some of those locations.
Then, Mr. Turnquist, I don't know if you can see your TV or your screen, but if you could put up the number 11 that I drafted. As I was working to try to figure out how to get you in the process, Mr. Turnquist, I think it's best that you become a party, and so because this is an expedited and we don't have an ALJ to make decisions, I thought I would empower the executive secretary to approve or deny intervention petitions. This is meant to accommodate you if you want to become a party, and so and I would encourage you to become a party. And so I just wanted to hear from you whether you would be willing to do that, and I think I would then encourage the parties here to include you on the discussion. So let me know your thoughts.
I'm happy to help. I mean, as a technician of 30 years with this company, I understand that technology has changed. I mean, it's not the same world it was then. I just want to make sure that our customers are treated fairly as we transition.
And so if you need any help, certainly contact our staff and they'll help you to file. It's nothing very complicated to file a petition to intervene. And we'll make sure that you're included. I assume Mr. Barlow, even though you're not seeing much space in the discussions, you're okay having Mr. Turnquist in those discussions early on here. Are you now?
Thank you, Chair. Commissioner Tuma. I mean, we're happy to communicate with the CWA. I can't confirm what position we take if they try to intervene. This is not a contested case, so intervention doesn't have the same process or steps that it would in a different proceeding. Right. But I'm sorry, I don't know if I missed it, but I feel like I'm just seeing 11
Just seeing
for the
11
first
because
time.
it just drafted today, so. So yes, you have a right to object, I'm not saying, but I would hope that you would include them in your discussions early on. Again, we're trying to move expeditiously. I want you, of all the people here, I'm for dereg, okay? I've been very clear. I've voted for every dereg bill in my life, so, but I have an obligation,
Bad decisions.
yeah. But I have an obligation under the statute here to make sure we are following the statute carefully. And so I'm pretty much where I need to be, Madam Chair, so I'm happy to make a
I was real
motion
happy
or-
with where you were going until that last comment, Commissioner Tuma, because I think your comment about being for dereg is, and maybe I'm riffing a little bit off of Mr. Turnquist here, but Mr. Turnquist, I think you understand better than I do, certainly, that, we have this statute that was passed by the legislature, and we have to do our best to effectuate what the legislature told us to do. But to Commissioner Tuma's, and I know you didn't see it, new modified 4, I think the importance of having CWA involved is finding that is helping the commission determine that the filing requirements that are required under the statute are robust enough for the public and your workers to be able to understand. Like that's one string that we really do have control over, or at least. And so I really like the way this is headed, or your modified 4 is headed. And to Mr. Barlow, like, I sort of understand what you're saying, but the earlier, and I know I appreciate that the companies are willing to work with the parties on the process that's laid out. But from my view, like, if you ask the questions and the other ones of the public and get the information out there, that's going to help the commission effectuate the statute in the way that you're wanting us to do anyway. So I think it's incumbent on the telephone companies to work with the parties here for the actual meetings that will take place that will help inform the public about the new law. And so maybe I'm picking a scab here that we can move over, but tell me again what's wrong with modified TUMA 4 that you're not real comfortable with?
Thank you, Chair.
Don't think, is it because is it the first part about find the petition incomplete? Or no?
Thank you, Chair. I have several concerns with TUMA 4. The first one is, yes, we feel that our petition is complete.
But sorry, I'm not trying to argue, but I am. But the way I read it or talked about it with staff was that part of your petition still includes the outreach plan to the public to inform them about their other options that are available to customers, is it not? And so that's how I read TUMA New 4, that we're still in that process of determining the notice requirements to the public, and that's what you're going to work out with the other parties, and then we'll move through the docket, and that will help us determine whether the petition should be granted in the end.
Thank you, Chair. I think I understand what you're asking. My apologies if I miss. We feel that our petition is complete. We have agreed to provide some of the additional information that's requested. We don't necessarily think that was required to have a complete petition, but we're willing to provide it. The things that we've left off our list are the things that would be burdensome or that would be more relevant to a decision about whether our technology is an adequate replacement. And so that's where our focus is that's a decision that's going to be made by the FCC. And so that information isn't needed here, and what we want to make sure that this is focused on the customer transition plan which we're here to cooperate with the commission on doing the customer transition plan, but not in approving the discontinuance, which is a decision that will be made by the FCC. So my primary concern with the modified 4 is that in combination with modified 7, it's creating an awful lot of process steps that they're going to add comment periods. They're going to have us back at the commission for every disagreement, and that's going to add time. And once the FCC approves discontinuance, which we expect is going to happen relatively quickly, possibly tomorrow, anything that inhibits us from moving forward with that is a potential problem that we just don't think is necessary to work through today. We think that the package we've outlined gets us moving forward. It avoids a very challenging discussion that we don't need to have about legal issues. Whereas I'm concerned that this puts us on a path to have that legal discussion, not necessarily today, but to have it when we might not need to have it at all.
I don't know what legal discussion he's worried about having, because I have an obligation under a petition you filed. You filed this petition under Minnesota statute. I have an obligation under Minnesota law, if you're going to disconnect copper customers that you used to have, a state required, I know there's a federal requirement, but there's a state requirement that you provide service to. And so now we're going to not provide service, and we want to make sure that they have full notice. I don't care whether I discontinue or have to make a discontinuous decision. I don't care about that. I have to apply 181. That's what I'm supposed to do, and that is I need to make sure everybody knows who their adequate providers are, okay? How we establish what adequate providers are. All of that information is what our state statute requires. I don't know what the feds are doing. I don't care. I have a petition you filed, and so I think it's pretty clear, and I think the department and OAG think it's clear. This is the process we get there. I can't help you that if you disagree, we got to create a decision process. If we're not going to go in front of an ALJ, it's us. I'm trying to speed it up by giving our executive secretary some authority, but I want to be also careful there because this is the first time we've dealt with this, okay? And so if we're going to deal with it the first time, we want to make sure we do it right and set a good precedent. And so that's what I'm trying to make sure I'm balancing here. It's nothing too tricky about it, so when you're ready, I can make a motion, but.
Commissioner Sullivan.
Well, that was helpful, Commissioner Tuma. I guess, Mr. Barlow, like the statute 237.181, isn't that a statute that the telecom industry brought to the legislature?
Thank you, Chair Commissioner Sullivan. I think so, but I have to say I was not personally involved.
I know the answer is it is.
So I guess that was right. But
I guess what I find a little, sorry.
Commissioner, I do just need to say that since that statute was passed, the FCC has taken a very significant action and has put pretty significant things in an order that state laws that interfere with the FCC's authority to approve discontinuance of missed jurisdictional service are preempted. Now, I want to be clear. We did not recommend decision option 1. That's not what I'm recommending today. We don't think that conversation is necessary. But what we are saying is that 237.181 has to be applied in a way that does not interfere with the FCC's jurisdiction. And we think that, Commissioner, with all respect, Commissioner Tuma, we think that your decision options take a step in that direction that's not necessary, and that our package would move forward without those concerns.
You won't know that until there's a final order, so that's.
So, Mr. Barlow, I am not familiar with the FCC particular decision that came out that you're referring to. I know that something happened, but I do know that federal agencies are always deferential to state authority and are always, they recognize that there is a nexus between state and federal authority, that it's not always a black and white zone, that it's very gray, and they are always deferential to state authority. But they're also, as a federal agency, they always are going to say, well, there is a supremacy clause, and they are going to say, when there's a conflict and it's a clear conflict, federal law, of course. But that being said, this is a statute that the industry came to the legislature with, and no less than a year ago said they would do this. And now they're saying, maybe not. And I just think that feels a little bit like they're playing with, crooked dice, so.
Thank you, Chair. Commissioner Sullivan.
And you can feel free, I know you've already had to do it once. Put the high dudgeon on and go. But, I mean, it just is, I think it stinks.
Thank you, Chair. Commissioner Sullivan. I understand the frustration. I do want to reflect, though, we filed the petition. We did not take the position, and we're not taking the position that statute's ineffective. We're here to cooperate with the commission, making sure that customers get the information that's required by the statute. We think we've done that, and we think that some of the extra things that people are asking for are really targeted at doing a reevaluation of what's an adequate replacement. That's what we're concerned about.
Commissioner Hom.
Thank you, Chair Sieben. So I understand we have to deal with the legal and law, but I think, however, we are talking about potential people's life. This service has a potential impact to people's life. And personally, I was tracking what's happening in the UK transition. There was a 2-year delay, plus I think there is a severe penalty for certain company due to this potential issue. I think that's why your industry was asking legislators to create that law, state law, so you guys can avoid that situation. Being said, I think just checking the box with the law and exercising federal agencies' power, I think we have to deal with this one properly. Otherwise, today's energy affordability discussion in politics can become copper wire transition problem. This can be the front page of every newspaper. So that's why I think Commissioner Tuma is saying that we should do it properly. So I hope that's the understanding of the industry.
Thank you, Chair. Commissioner Hom. I had wanted to have an opportunity to say earlier, but I do want to make clear, we are only proposing to discontinue copper service for specific customer locations that have an approved adequate replacement, which is Verizon Wireless, Verizon Fiber, or Verizon Fixed Wireless. And we're also committing that no customer is going to get left behind. So if we've gotten approval for a location for fixed wireless or mobile, and our techs go out there and the service doesn't connect, that person's going to continue to get copper service. We're not disconnecting anyone from the connectivity, and we've committed to file on September 10th more information about how our technology interacts with things like TTY and medical devices and other equipment like that where it's critical. We're here to cooperate with the commission and do this right so that we can get customers on better technology and make sure that everybody is connected.
And Mr. Barlow, I think we share the same goal of informing the public, and that's why I'm still really strongly supportive of Commissioner Tuma's modified 4, because it shapes the parameters of your customer transition plan and the notification to the customers about what their alternatives are. And so, I mean, I think we're moving in the direction that the legislature told us to here. If the commission moves forward with Commissioner Tuma's decision options, and it's going to take work on your client's behalf to really work with the department, the CWA, and the OAG to do that outreach that is required under the law and the necessary information, because as well as those of us sitting up here, because you used to work at the commission, the public is going to call, not your companies that you're representing now, but they're going to call the public agencies to ask for help with what's happening. And so we have a vested interest in making sure that your outreach to these customers is robust and complete. So hopefully that happens and we can agree to disagree on portions of this, but we share the same goals in educating the public about their options. So, Commissioner Tuma, any other questions in your...
Nope.
Commissioners, any other questions in your overall motion or overall on the docket?
I guess I just want to ask Commissioner Toom, if he wants to take back his dereg comment. No, just-
Well, I meant that to say.
That was an
even
extra 20
even I am, even I am with you on following the law. Okay, I would move to a modified 2, a modified 4, modified 7, and the new 11 to allow for the delegation of the executive secretary to approve interveners.
All in favor of Commissioner Tuma's motion, please say aye. Aye. Opposed, the motion prevails. Thank you, everyone. There's no other work before the commission. We're adjourned for the day.
It's a kind of an interesting thing, too. There's a lot of, because the federal government did try to fill the space, but they really didn't. So we really won't know.